Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning. Please be seated. All right. The first case is Columbia Gas Transmission versus RDES, and Ms. Laguno. It'd be a pleasure to hear from you.
Good morning, Your Honors. May it please the court, my name is Joy Laguno, appearing on behalf of Defendant Appellant RDFS LLC.
Is she coming forward to the...
Oh, I'll come forward, Your Honors, if you prefer. Can you not hear me? Your Honors, this appeal challenges an order that undermines foundational principles of property law and awards contradictory relief on irreconcilable grounds. In a single order permitting Columbia...
Can you move that down a little bit? I want to be sure. That's perfect. I just want to be sure I catch everything of what you have to say.
Thank you, Your Honor. In a single order permitting Columbia's access to the entirety of appellant's 39-acre property, the district court made two diametrically opposed rulings. The court granted the extraordinary remedy of preliminary injunctive relief, despite its simultaneous grant of summary judgment, holding that Columbia is entitled to condemnation of the property under the Natural Gas Act.
Did the court introduce its condemnation discussion with the word as an alternative?
No, Your Honor.
It didn't say alternatively?
Although the motion was in the alternative, the court...
I'm talking about the order.
Yes, the order explicitly granted both motions.
Well, I know what it did, but did it introduce the second one with the word alternative?
No, Your Honor, it said, I have the, it says, Columbia has established that it possesses a substantive right to condemn property. Thus, Columbia's motion for partial summary judgment is hereby granted. So it stated both without stating in the alternative. These holdings cannot coexist. It is a fundamental principle of law that where an adequate legal remedy exists, an injunction is not merely disfavored, it is impermissible.
If there is a pre-existing easement agreement, which is the product of condemnation some period back or negotiations, whatever, a condemnation is unnecessary, isn't it?
Your Honor, we maintain that the easement is limited in scope,
I'm not
more
talking
limited.
About that. I'm talking hypothetically. If there is a pre-existing easement over property, a condemnation of that same property for the purposes of obtaining an easement would be unnecessary.
Correct, Your Honor.
So if we find in this case that there was an easement over the property and the easement was being enforced, then we need not address condemnation, right?
The issue here is the easement is limited in scope, narrower than the condemnation.
My question is a hypothetical one. If we recognize the easement as existing and recognize the easement, then we don't need to address a condemnation to create such an easement.
That is not correct, because the condemnation sought here is geographically broader. So regardless of the court's finding on the easement...
I thought it's geographically narrower. The condemnation was 50 feet easement, and the easement is undetermined. It extends over the entire property.
According to...
The language of the easement, right?
The language of the easement defines it with a 24-inch pipeline. The over 50-year use of the easement and Columbia's own...
I asked you what the easement said. Did the easement grant it over the entire property?
No, Your Honor. The language, term of art, all that certain tract of land, according to West Virginia jurisprudence, does not grant an easement to all of the property.
I didn't say that, didn't I? I asked you about the language of the easement. Let's start with the language of the
The
easement.
language of the easement grants a right-of-way for a 24-inch or less pipeline across the property.
What's the
But
language?
it also grants the right to construct, operate, and maintain the pipeline, does it not?
Yes, Your Honors. According to West Virginia Supreme Court jurisprudence, multiple Supreme Court cases state that any language stating all the property or all the parcels is insufficient as a matter of law and void for uncertainty unless there's extrinsic evidence that can show the bounds of the right-of-way. All the property is not, as a matter of law, adequate to define a right-of-way. That is why the right-of-way here is narrower than the condemnation sought.
The district court said West Virginia law, and he was quoting from the Appalachian, the Keel versus Appalachian Power, said power company has the right under a general right-of-way easement to enter upon the land to maintain and repair its equipment to the extent necessary to the safe and effective operation of that equipment.
Correct, Your Honor, but upon reading of that case, it was not about a geographic scope of a right-of-way. It was about the use of the right-of-way and the use of
requested injunction
herbicides.
here requested just access to the property to carry out the easement, and the order of injunction granted that. It didn't define it at 50 feet or 24 feet or the whole property. It basically said it granted what was requested, access to the property to maintain and correct this pipeline in order to prevent subsidence. And that was granted, and as a preliminary injunction, it was granted without defining the terms and scope. And it seems to me if you believe the exercise of that right is violated during the course of the maintenance, you could come to court and redress that, either by getting maybe an injunction or getting damages, which they will have to pay. But at this point, the easement, the injunction requested access to the property to maintain this pipeline, and the court granted that, and it did not define boundaries or anything. So why wouldn't that just be a normal procedure to do that?
That is not correct, Your Honor. The court's order specifically states that the easement grants all of the access to the entirety, all of the property.
Show me the language. I'd like you to start, we disagree on what the records say. Show me the language of the order, the injunction order.
Your Honor, I do have it. Your Honor, both in the explanation of what,
I don't want the explanation. I want the order, the actual order, injunction.
for the foregoing reasons, Columbia's motion for preliminary injunction is hereby granted.
That's the language, right? And then you look at the motion that's requested, and you look at the motion that's requested, and they just grant access to maintain it. They don't define this tree needs to be chopped down. They don't say it's 50 feet. And basically, they're granting access under the easement to maintain the pipeline, and the court granted it preliminarily.
But in its findings of fact and conclusions of law section, it states that it's granted because they have access to the entirety of the property. And in RDFS's post-judgment motion.
That's what the easement says.
Your Honor, but that goes against centuries worth of Supreme Court jurisprudence in West Virginia stating that an easement cannot be all of the property. In Highway Properties versus Dollar Savings.
So what you're saying is the easement is illegal?
It's either defined by extrinsic evidence and the 24-inch pipeline that was constructed, or it is void for uncertainty.
Right. If we had a question in this case as to where they're going to maintain it, but in this case, the gentleman from the company testified that they bring on the equipment, they do this along the line, they bring on the heavy equipment, they operate usually within the 50 feet, sometimes they have big equipment that has to be moved away from the a pipe so it doesn't damage it. But this is all a very pragmatic issue. The issue is they have access to maintain the pipeline, and the lease says they have access to the property. Now, you're saying the easement is defined by the practice over a period of years under West Virginia law. That may be, but there's no fight here over that. They asked for an injunction to get access to maintain it, and the court said granted as a preliminary matter. It didn't say you can't go beyond 50 feet or you have to stay within 50 feet. I mean, this is all, you're worrying about something that may happen or may not happen.
But Your Honor, here, the record shows that it has happened. The RDFS went back to the court and stated that they've been going across the bounds of even what they requested in their motion. We had a motion stating that, and the court again repeated that, no, I gave them access to the entire 39-acre property. So that there is a practical consequence that is happening because of the judge's inconsistent order. It departs from West Virginia law, that it cannot be all of the property. It has to be clear, definite, and defined. Otherwise, it's void for uncertainty. So they would not have any access. In addition, if summary judgment controls. A summary judgment is a final adjudication. So you can't have preliminary relief that trumps the summary judgment adjudication that it was a finding that condemnation was appropriate. That should trump over a preliminary finding. There are practical consequences as well. For the preliminary injunction, we aren't able to get just compensation as we would under a condemnation proceeding.
Counsel, I come back to the questions that Judge Niemeyer raised at the beginning, and that is the language of the easement. And I don't see any width limitations in the easement. And it seems to me to be broadly worded. It says through a pipeline, and then there's a whole string of verbs: operate, maintain, replace, and remove said times, over and through all that certain tract of land. The problem, I think, for your case is that the easement is written in very broad terms to allow a power company to do what was necessary to maintain a natural gas pipeline. And I think you're trying to read limitations into the easement that are simply not there.
But that is necessarily what West Virginia binding precedent mandates. It states if there is no geographic bound, then it is void for uncertainty, unless the extrinsic evidence, the actual use of the easement, here it's the pipeline, where the pipeline is located, defines the bounds. Multiple West Virginia Supreme Court cases, and I'll direct the court to, we referenced a West Virginia Law Review article authored by John Fisher that details the multiple Supreme Court cases that state that. It's either void for uncertainty or it can be defined by the use and extrinsic evidence of the parties.
What did the district court, what error did it commit in issuing the injunction?
It simultaneously granted a summary judgment motion,
You keep saying
which trumps.
simultaneously. It did rule in the same document, but as you say in your motion for appeal, the February 28, 24 order granting motion for preliminary injunction or in the alternative, partial summary judgment and immediate access.
That is not what the court ordered.
That's what you appealed. That's your document I just read. And that was what the court, that's the way the court labeled it.
The court did not label it as or.
What page is the court's order on, do you know?
The conclusion, or the order starts at, I think 321 is the conclusion.
321, thank you.
But it starts earlier, I believe.
Could we maybe explore some of this on your rebuttal time? All right?
Thank you, Your Honors.
Yeah, thank you. Ms. Bagnell, I'd be pleased to hear from you.
Thank you, Your Honor. May it please the court, I am Nicole Bagnell and I represent Columbia Gas Transmission. And Your Honor, I think Judge Niemeyer hit on the exact issue here. What about the court's preliminary injunction order is appealable or is under appeal? And the answer to that is none. Judge Bailey issued an order saying that Columbia could access its existing pipeline to undertake necessary maintenance to protect the pipeline from undermining by longwall mining being done by a third party, to protect public safety. And nothing raised by RDFS addresses that basic fundamental basis for the injunction. In their statement of issues, they address three. First, to relate to this alleged conflict, and I don't believe there's a conflict, Your Honor, and I can get into that more. But the third is that the court's order granted more access than was sought by Columbia in its condemnation action. But here, we're here today on the preliminary injunction. They did not appeal the summary judgment.
Oh, I think they did.
Well, they say they didn't.
Well, sure, what's wrong with that?
Well, Your Honor, what's before you is what is under appeal. And RDFS...
They appealed the preliminary injunction and they appealed the condemnation order explicitly.
Your Honor, they appealed the order, but they make clear in their briefing that they did not appeal and do not contest anything that was found by the judge in summary judgment. So they have not raised any
Well,
issue.
We have the latitude of affirming a district court on any ground that's apparent from the record. And it seems to me that your strongest point is where we should begin, which is, what does the language allow of the easement? The whole question is that what the easement gives you the right to do, and the easement does not contain within it the kind of width restrictions and otherwise that the appellant would like to have part of it, that the appellant is reading restrictions into the easement which just aren't there in the language. That's, you can't have a lawyer's, attorney's argument amending the written instrument.
Exactly, Your Honor. And the case law that RDFS relies upon from West Virginia doesn't do that either. The plain language, as you state, is clear, and the case law that Judge Bailey relied on in support are two pipeline cases that say the court looks at what's reasonably necessary to effectuate the purpose of the easement. Here, the right-of-way says that it allows Columbia to construct, operate, and maintain a pipeline over all that certain tract of land. And what Columbia is clearly doing, it's not disputed, is maintaining its pipeline. The case law that RDFS relies upon is not relevant to a right-of-way like we have here, but in fact addresses deed reservations. And those cases that are specific to deed reservations hold they must describe what is being reserved with certainty. But here we have the affirmative grant of a right-of-way. And those cases that say the court can look to extrinsic evidence, again, are limited by the fact that it's a reservation in a deed. And I think most tellingly, RDFS relies in its briefing on a general rule from the Mary Helen Cole versus Hatfield case from the Supreme Court of West Virginia in 1914, that an easement once set cannot be changed. But that ignores the holding in that case, which is the easement they were looking at had language that granted broader rights. So the court, even there, didn't apply the general rule. The court said the language of the easement allows greater rights, and that's exactly what's true here as well. The language of this right-of-way allows greater rights.
It's important sometimes not to take cases that have a very simple core and make them more complicated than they are. And the question here is, did the preliminary injunction or the terms of the preliminary injunction within the terms of the easement? And did the preliminary injunction follow the written instrument? Just speaking for myself, I think it did, because I think that the easement here is very broad and is very open-ended, and the whole thrust of the easement is do what you have to do to maintain the natural gas pipelines in a functional state.
Yes, Your Honor, and that's what the court said Columbia could do, and that's what they did.
Is there anything further?
Your Honor, I'm happy to address any questions that the court might have. I'm happy to address the alleged conflict between the two parts of the judge's order, if you would like to hear on that.
That's a bit of a red herring. I think the question here is, does the record afford grounds for affirming the district court and the preliminary injunction? And there, it was within the terms of the written easement.
Yes, Your Honor.
Unless my colleagues have questions. Judge Berner, do you have any questions? All right,
Thank you, Your Honors.
thank you, okay. We'll now hear from Ms. Laguna. You have some rebuttal time.
Thank you, Judge. Your Honors, going back to the exact language in the court's preliminary injunction order, the court stated that Columbia has the right to use the entire property to operate, maintain, and replace the line.
Tell me what the easement says.
The easement gives the right to construct a 24-inch or less pipeline and maintain, operate the line. However, Your Honors,
Hold on
It says
one
just a minute.
second.
You're
Let me
talking about-
ask the courtroom deputy, is the timer working here? I can't.
It's on the screen.
Oh, it's, okay, that's my fault entirely.
No, you're fine.
Okay.
The easement provides that Columbia has the right, quote, to operate, maintain, replace, and finally remove the pipeline over and through all that certain tract of land, according to the easement provides the right to use the entire property to operate, maintain, replace, and finally remove the line. Now, that's the language of the easement that is granted. It's granted to put a 24-inch pipeline there, but it's granted over the entire property as necessary to maintain it. Now, if we had a huge piece of equipment that had to be brought on to maintain the line or to excavate or something like that, it would seem to me the easement naturally covers that.
under West Virginia law, it does not, Your Honor. There are four.
Well, you know, you keep switching off. Every
Then
time I
I
ask
will-
you about the scope of the easement, you misrepresent to me what I believe is the language of the easement. And that's all I'm addressing at this point. I wanted to know the scope of the easement. And likewise, when the judge granted the order, it granted the alternative motion. You said they didn't, and I'm just looking here, and that's exactly what the court did at the end. For the foregoing reasons, Columbia Gas motion for preliminary injunction or in the alternative, partial summary judgment is hereby granted. Now, it seems to me that when the court uses the word in the alternative, and that's what you appealed, that it is if it's necessary. In other words, if the lease is not found to be applicable or something's wrong with the lease, the alternative would be they'll condemn the property to create a lease. But there is already an easement there, and if the court finds that the easement's there, and if we affirm that, you don't get to an alternative.
Your Honor, to go back to your first point, there are multiple Supreme Court cases that state any language that says all the property is void for vagueness. To quote highway properties,
I don't
the
understand why
easement.
it's void for vagueness. It's a described piece of property, the boundaries are described on it.
But the boundaries are not.
Meets and bounds of the property are described.
Not in this easement, Your Honor. There is no beginning, according to West Virginia case law, it needs to be geographically
No,
subscribed.
let's stick with the easement just once in a while.
The easement.
We talk about the easement, then we can talk about the law. But does the easement describe the parcel of property on which this easement is granted?
No, it does not. It just says there's a 24-inch right-of-way.
It doesn't describe the property?
It describes the
What page
tax
is the
parcel.
easement on?
It describes the property, Your
That's
Honor.
what I'm talking about.
But it doesn't describe the bound of the right-of-way.
No, I didn't ask that, did I? I asked the property. Did the easement describe the property?
Yes, there's a bound
Meets and
description of the
bounds.
property.
And then it said it's granting an easement over that property.
There's multiple cases with similar language where the court, and I quote, says this is totally an inadequate description. That is from the Supreme Court. It has to be definite and certain from the actual meets and bounds.
I don't know how it can be more definite if you have a meets and bounds description
But
of
that is not
property and you grant an easement over the property.
It is a right-of-way agreement, Your Honor. It's not a general easement. The right-of-way has to be narrowly defined. If you read the case law that we support, and there's a specific section in this West Virginia Law Review article.
The court didn't say didn't say that the pipeline goes over any other direction. That's described, and that's actually shown on a plat. But the easement grants the easement for a 24-inch pipeline and the right to maintain it over the entire property, and that's the language. Now you say West Virginia imposes a boundary line. The court didn't deny that. The court just basically granted access to maintain this pipeline.
That is not what the court granted in the subsequent order, Your Honor. It's just to make clear, West Virginia law states there needs to be a geographic location of the right-of-way, not just a meets and bounds description of the property. If the right-of-way at the beginning, the end, and the width is not described, then it is void for uncertainty, unless there is extrinsic evidence that shows the location of the right-of-way, not the property, the right-of-way itself. Multiple cases in West Virginia state that. That's why this order is wildly inconsistent with binding Supreme Court precedent. Again, the West Virginia Law Review article, to clarify, has a whole section on the width, defining the width in West Virginia of right-of-ways, and that is what they state. It details multiple cases, Your Honor, if I'd like to point those out, that state this, that all of the property is insufficient as a matter of law in West Virginia, unless it could be saved by extrinsic evidence. Here, Columbia itself conceded that they were only using 50 feet. That is the extrinsic evidence that defines the right-of-way. It's been used within 50 feet for over 50 years. That is the extrinsic evidence, and going beyond that is, again, contrary to West Virginia law. Second, Your Honor, for the summary judgment motion, that is the proper remedy. Letting the summary judgment ruling final adjudication stand allows the property owner to proceed with just compensation under the statutory protections of the Natural Gas Act. In contrast, the preliminary injunction deprives this remedy or any recourse for RDFS. That is why, Your Honor, in close, we request that the court vacate in its entirety the preliminary injunction, because it is contrary to West Virginia law, contrary to multiple cases with similar language of all the property stating that is insufficient as a matter of law and void for vagueness, unless it can be saved by extrinsic evidence. The extrinsic evidence was conceded by both sides. There was no factual dispute. Columbia even states in their motion that the permanent easement is only 50 foot in width, end quote. So there is no dispute as to that. I implore the court to follow the 100-century-old precedent of West Virginia Supreme Court jurisprudence that is binding in this case, and vacate the preliminary injunction in its entirety.
Thank you very much. And we will come down and greet counsel and proceed into our second case.
Thank you, Your Honors.
case, Pacham Solutions versus the Small Business Association. And, Mr. Johns?
Good morning, Your Honor. My name is Milton Johns. I represent the appellant Paysom Solutions International. Representative of the client is with me today, Joseph Schmitz Esquire, as well. Our case is fully briefed before the court, so I'm not going to read from it, but there are some very salient points that I want to bring to this panel's attention. And I think that footnote 17 in the government's brief really captures this case and our argument very well. Footnote 17 of their brief says, to the extent that the May 2020 payment stoppage is a reviewable final agency action, the SBA similarly has relied solely on the single explanation for that decision provided to Atlantic in September 2020 and to the plaintiff in May 2021. Now, the September 2020 document that they're referring to is an email that takes place in September 2020, months after the stoppage in payments. And the SBA rep from Little Rock, Arkansas acknowledges that there's been a misreporting of the status of the loan, and that may be the cause for the stoppage in payments. But the fact of the matter is...
Counsel?
Yes, Your Honor.
Under the CARES Act, who is responsible for deciding whether the loan should be in liquidation status? Isn't that up to the lender?
In liquidation status, Your Honor?
Yes.
That would be the lender's decision, the lender's report. And at this point...
And who was the email from?
The email, this is Joint Appendix 37. Oh, I can pull that up right quick. The email is from Carvis Campbell, the loan specialist, SBA, and it goes to Atlantic Bank representative, Atlantic Union Bank, who's been trying to find out why the payments have been stopped. And it reads, it appears the loan has been misreported and showing delinquent, which may have resulted in not receiving payments. Now again, this is September 2020, and this is months after the payments have stopped. Now the record, in fact, doesn't show any of that, the contemporaneous record. We have...
There was a 2-year investigation of the loan and the condition of the loan, and the conclusion of the investigation was that the loan really had never been regularly serviced or had been serviced for only a very short period of time. And why should we overturn the results of that investigation?
Well, because, Your Honor, that investigation actually had nothing to do with the action, which was the stoppage of the payments. And there was nothing in the record to indicate that in May 2020, when that decision was made, when the payments were stopped, that any of that was the case. I mean, there is JA 35, there's one page in the record that shows information that originates at the time of the decision to stop the payments. And even then...
When did the bank send its 1502 report?
Well,
That in April?
we believe, looking at the June 2021 printout, which is page 1 of the administrative record, there are entries on April 7th, which show that it was current. That's a 1 status. We have an April 21, it is a 1 status. We have a May 5th entry, which shows a 2 status. And that doesn't mean delinquent. These are the SBA guidelines for this report. That just means it's 30 to 60
Right,
days
but
payment.
isn't the status of the loan and the question of how long it was serviced, isn't that a question for the agency in this case? I mean, we can't retry the whole matter up here, and the liquidation status of the loan and the question of how long the loan was serviced and everything, these are, it seems to me, factual questions that the agency is more, might be more competent to resolve than we are. I mean, we're sort of stuck with this record, aren't we?
Well, you are stuck with the record, Your Honor, and so is the agency. And there is no information in the record as contemporaneous to May 20th on why the agency stopped those payments. Everything else in the record is post hoc. They made the decision, they stopped the payments. Even the decision, the May 21 letter, Payson is inquiring, why has the payment stopped? Why did the payment stop? They can't get any answers.
There was a reason that they made the decision to stop the payments, and that was that the loan had not been serviced.
Well, there's nothing in the
I realize
record.
you take issue with that finding, but it is a finding, and it came after a significant period of investigation. There wasn't just something that the agency snapped off. They investigated the status of the loan and whether it had been serviced, and they came to a conclusion, and you think they came to a conclusion sooner than they should have come to the conclusion, but it just seems to me that the conclusions to be drawn would lie with the sort of primary finder of fact or the primary investigator here, which is the agency. I mean, I'm just trying to find out what was exactly arbitrary and capricious about the agency's actions here.
Well, it's arbitrary and capricious because there are no facts in the record with contemporaneous to that action to support that decision. We have the stoppage of payment in May of 2020. The total information in the record are 2 entries on a report generated in June of 2021 that indicates that the loan was in a 30 to 60 day payment. There's no determination in the record, there's no information at all that the loan was in liquidation then, that the loan was not in regular servicing. There's just nothing. And in fact, the email that they rely on in this footnote 17, the SBA says, it appears the loan has been misreported, which may have resulted in not receiving payments. So in effect, in May of 2020, the SBA is saying, it looks like there's a mistake here, and as a result of that mistake, they've stopped the payments, but there's nothing else in the record.
Was the payment in fact made? Was it later determined that a payment was in fact made?
Well, the payments weren't made because it was the SBA's responsibility to make them. And so it's an impossible loop, Your Honor. The SBA made 2 payments under the CARES Act.
Well, don't you have
April
a
and May.
responsibility to prove that the loan was regularly serviced, at least for a 6-month period?
Well,
Isn't that your burden?
no, the burden is to show that there's nothing in the record upon which the agency could make that determination.
Well, but don't you
And
have?
that's what the district court,
Don't you have something of a burden to decide, to say, look, you're wrong here, the loan was regularly serviced?
well,
Why were 5 separate amendments necessary here in order to make the repayment easier? The record, the agency contends that at the time of the agency decision, only 7% of the principal had been retired. And I think also at the time of the decision that there were 5 separate amendments designed to make repayment of the loan easier for the for the business. And yet, you know, they keep amending it and amending it and amending it, and very little of the principal ever gets retired. And so what are we to make of that?
Well, Your Honor, that really is irrelevant because the loan that was presented for approval for the CARES Act payments was at the Fifth Amendment. So that was presented to the SBA and it was approved for the CARES Act payments. The SBA makes a decision, they take an action sometime in late spring, early summer to stop those payments. There is nothing in the record as to why they did that. Even the post hoc determination, again, there's nothing in the record. It's all discussion that takes place in 21, 22, and 23, but no one can point to when that loan either went out of service, wasn't in regular service. None of it is there. And so the district court is bound by the record, and the agency is bound by the record in making that determination. And again, there's one page that have two data entries that take place a year after the decision. So the issue of the loans is, I think, the status of loan. I think that's part of the narrative that the district court was following, but it's not the law and it's not the record that the decision was based on.
I'm concerned about the fact that you seem to be sort of retrying this case on appeal and saying that the lengthy investigation on a two-year investigation, you seem to say that everything that went on before the agency is just irrelevant. It didn't matter, and that you're saying no, this loan was regularly serviced, and the agency's conclusion was just crazy, and all the rest. But I'm not sure. There's an awful lot of evidence here. It appears to me that it indicates the loan was a lemon, and I'm concerned that you're trying to get the government to bail you out of a bad loan. And I realize that the purpose of the CARES Act is to help small businesses through proper loan guarantees, but at the same time, I don't think that the CARES Act wholly absolves bankers of at least minimally responsible loan practices. And I think that the whole question of regular servicing, which is undefined in the statute, but it's there, and I'm just worried that I just don't think that the CARES Act, as important as it is in helping small businesses during a really rough period, but I'm just not sure that banks are completely let off the hook, because we all know that what are responsible lending practices and what are not, and you have to do some basic investigation of the loan recipient and the likelihood of repayment. And this seems to me, you know, from what I read in the agency record, it seems to me to be a very, very ill-advised loan. And I'm just not sure what's arbitrary and capricious about the agency taking that into account.
Well, Your Honor, and, you know, this, the Dow AgriScience case that Judge Niemeyer's panel said that when the court is considering this, and this court reviews this de novo, the court must only consider the record made before the agency at the time the agency acted. The agency record does not refer simply to the facts presented to the agency, but also includes the reasons given by the agency for taking the action. The court may only look to these contemporaneous justifications in reviewing the agency action. Everything that you described, Your Honor, takes place 1 year, 2 years, 3 years after the
Okay.
stoppage in payments.
All right, well, you have
And I'm
some
out of time,
rebuttal
Your
time,
Honor.
but I'm going to ask, hold on a minute, I'm going to ask my co-panelists if they have any questions. Judge Berner, do you have any questions of counsel that you'd like to ask?
No, thank you.
We're fine, thank you.
Thank you, Your Honor.
Mr. Humhart.
May it please the court. Assistant U.S. Attorney Peter Baumhart on behalf of the defendants. On 2 independent bases, the Small Business Administration determined that plaintiff's $5 million loan was not eligible for the CARES Act subsidies that it seeks in this action. First, the loan was not in regular servicing status because it had been deficiently serviced for 1.5 years before the CARES Act was ever enacted. Through 5 separate amendments, in fact, plaintiff failed to pay down the principal on its loan in any meaningful way. The second basis for the SBA's decision is that after the CARES Act went into effect, plaintiff and its lender struck a highly questionable new deal where the SBA would pay off more than $3 million of the loan, repayment terms that were totally at odds with plaintiff's historical and then present ability to pay.
Wasn't the 6th modification after the cessation of payments?
That's correct, Judge Berner. The 6th Amendment was entered into in May 2022, after the SBA had undertaken the CARES Act subsidy payments.
And didn't the investigation letter say that the first 5 modifications were proper?
I'm sorry, I missed the last part of your question.
The investigation letter, I believe it said that the first 5 modifications were proper?
I'm sorry, the 6th Amendment said that?
The investigation letter, did it not say that the first 5 modifications were proper?
The investigation letter, I do not think approved the first 5 amendments as proper. I believe that the final letter from the SBA, which is in the record, made clear that that was part of the irregular servicing of the loan that formed the first part of its decision that there was no eligibility for the CARES Act subsidy payments. So stepping back to the 6th Amendment, this new deal violated specific regulations that would release the SBA from its guarantee, meaning that the loan was no longer a covered loan after that point. The evidence supporting these conclusions, which is all in the administrative record, is more than sufficient to justify the agency's decision that plaintiff's loan was ineligible for CARES Act subsidies. The record also makes clear that plaintiff received...
What's the standard of review of that finding? The question, obviously, the factual question is, as a matter of fact, was the loan actually in regular service for a 6-month period? And you say no, it was never, and there was no eligibility there. What's the standard of review of that finding?
Your Honor, to the extent we're talking about the agency's finding, that is reviewed under the arbitrary and capricious standard. The question of which is that whether the SBA relied only on relevant considerations, whether it missed any critical issues, and whether the administrative record flatly contradicts that conclusion.
So it's an arbitrary and capricious standard and a substantial evidence standard?
That's right, Your Honor. The record also makes clear that plaintiff received the notice and opportunity to be heard that due process requires, and that the SBA's decision faithfully applies the CARES Act. So to start with the APA, as I just said, the arbitrary and capricious standard requires the SBA to rely only on.
You had a 2-year investigation, and the recipient of the loan had every opportunity to make its views known in terms of the regular servicing?
That's correct, Your Honor. The SBA was asking the lender for all information on the loan's history, starting in, I believe, November 2020. Those communications continued through 2021. The plaintiff submitted an inquiry to the SBA Ombudsman in early 2021, which the SBA responded to in May 2021, explaining the reason for the May 2020 payment stoppage. And then plaintiff itself submitted an
What was that explanation?
The explanation from the SBA in May 2021 was that the loan had been, I think the term was in default, but it was essentially the delinquency that showed on the 1502 report from May 2020.
No, the investigation took place and the determination of default took place after the loan payments were stopped, is that right?
Yes, Judge Berner. So in May 2020, based on the 1502 report data that the lender submitted to the SBA, the loan was, as I understand it from the SBA, the sort of loan tracking computer program generated an exception and sort of kicked the loan out of the eligibility for further subsidies. And then
what data were submitted by the lender that prompted the cessation of payments?
The lender submitted a report that indicated in May 2020 that the next payment due date was April 15th, I believe. So it was showing a next payment due date that had already passed, and therefore the indication was that the loan was then delinquent.
The lender submitted that in May 2020, but the repayments were stopped in April 2020, the month before?
No, Your Honor. There were no further payments made after the SBA made the payments for April and May 2020. And those were due essentially at the beginning of the month. And so the 1502 report from May 2020 came after essentially the due date for the May payment, and thus no payments after that 1502 report were made.
So what you're saying is that the repayments stopped in May 2020, and then the investigation that ended with the 2022 report was commenced. So the investigation was commenced only after the repayments stopped. Is that right?
Yes, Judge Berner, what happened was obviously the lender submits this 1502 report data. So the SBA receives information from the lender indicating that the loan is delinquent. And then in late August 2020, the lender contacts the SBA saying essentially, where are the rest of the payments? At which point the SBA is on notice that there is a discrepancy between what the lender submitted and what they're now asking. And that's what got the SBA's attention and led them to investigate the loan. My understanding from the agency is had that investigation revealed nothing more than a bona fide error as to whether the loan was delinquent in May 2020, and assuming that there was funding still available under the CARES Act because the subsidy program was tied to specific appropriated funding, there would have been back payments made. But that's not what the investigation revealed. What the investigation revealed was a history of misservicing of the loan over the course of 5 amendments, and then a new 6th amendment that was not justified either by plaintiff's historical ability to pay or their then present ability to pay, and which in fact looked like just an attempt to get the loan off the books at the federal government's expense.
Why would the bank issue a 1502 that says it was delinquent when the SBA was making the payments?
Your Honor, we don't have the answer to that question. I think only the lender can answer why it submitted the information that it did. Again, the 1502 report is something that the SBA receives. It's not something that the SBA creates.
I understand, but your position is the 1502 report from the bank prompted the stoppage of payments.
That's correct.
And my question is, I thought SBA was making the payments then, so I can't quite figure out why the bank would say they were not being made when the SBA was making them.
Your Honor, it could well have just been an administrative error on the bank's part. We don't know why the bank reported that information, but that's the information that the SBA has. And I don't understand my colleague to dispute the accuracy of the information that was reported to the SBA at that time, although they disagree that the loan was delinquent at the time. But as I said, if there had just been nothing but a bona fide error by the lender in terms of its reporting, and that's all the investigation had uncovered, then the SBA would have made those back payments, assuming that there was still appropriated funding available to do so. But again, that's not what the investigation revealed. The best way I can think of to explain it is it's analogous to perhaps an officer on patrol seeing a car swerve, and the officer thinks, maybe the driver's intoxicated, pulls the car over. Driver's not intoxicated, but the officer looks in the back seat and sees a package of illegal drugs. In sort of a similar way, the discrepancy as to the May 2020 1502 report is what got the SBA's attention, and then its investigation revealed, separate and apart from a payment in April 2020, there had been major problems with how the loan had been serviced over the year and a half since origination, as well as the legitimacy of the Sixth Amendment that was entered into after the SBA was essentially on the hook for loan payments. I hope I adequately answered the question.
Yeah, it's a little strange. I think we review the final agency action, and then we go back and see whether the agency acted reasonably and so forth. But there's a bit of a curiosity as to why the SBA stopped making payments. There's a little bit something circular, because they say they stopped it because they got a 1502 report from the bank saying that there was a deficiency in the payments. Yet the SBA knows they made the payments.
Well, so Your Honor, it's, again, the way that it works is just that what the SBA gets is data. So I think we tried to flesh this out in our brief. The lender submits a 1502 report to a fiscal and transfer agent who acts as a clearinghouse to submit all data from lenders, all 1502 report data from lenders to the SBA. And so the SBA has a program that tracks the loans, which is what is the spreadsheet that's in the record. And so all that has is the information from the lender. It's not like the SBA was separately checking against whether some new system that would have been tracking CARES Act payments. And especially because the CARES Act essentially created this subsidy program out of whole cloth. And so it's not like the SBA had anything to cross-reference with. It was just relying on the lender to accurately report the status of the loan. And it is curious that the lender submitted the data that it did. I won't disagree with that. But the agency can only act on the information that it receives. And
Do we have a copy of the 1502 in the record?
we have, so I think it's JA35 is
No, that's just a summary. The 1502 report from the bank, we don't have that.
No, and I don't know that that itself is submitted to the SBA. Like I said, the 1502 report goes to an intermediary, the fiscal and transfer agent, and then the fiscal and transfer agent submits the data from those reports to the SBA. So what we have is the information the SBA receives from the fiscal and transfer agent.
And what's it show, on page 35, what's it show me?
It's going to show you that there are there's May 2020 entry that shows, I think there's actually two May 2020 entries that show that the next payment date is April 15th, 2020, which indicates that there is a past due payment.
So under the CARES Act, a loan is considered in regular servicing status unless it's considered in liquidation status, isn't that right? Or should have been in liquidation status?
Yes, so the loan is in regular servicing status as relevant here unless it should have been moved out of regular servicing status into liquidation status prior to the date.
So the November 2022 letter, it doesn't say anywhere in that letter that the loan should have been placed in liquidation status. It only says that the May 2020 amendment seems to have been improper. But did the SBA actually make a finding that the loan should have been placed in liquidation status as it was required to do under the CARES Act?
Your Honor, there are two explanations in the SBA's letter. One is about the May 2020 amendment, the sixth loan amendment. And the other is where it talks about how the servicing, I think phrase is, I'm trying to remember exactly, is the servicing on this loan did not comply with loan program requirements. And that is the
But
SBA.
does it ever say that the loan should have been in liquidation status? That's the rule under the CARES Act. That's the standard.
So it's what the procedural notice says in full on that point is that a loan that should have been moved from regular servicing status under loan program requirements. And so the reference to loan program requirements is, in the letter, is making that determination, is saying that this did not comply with loan program requirements, the servicing on the loan. And again, that is one justification for the SBA's decision. The other is the sixth loan amendment, which, as I mentioned, violated 5 separate regulatory provisions under 13 CFR section 120.524. That's A1 through 5. And so separate and apart from whether the loan should have been moved out of regular servicing status before the first payment date, the violation of those regulations releases the SBA from its guarantee. And thus the loan after that point, meaning after the enactment of the sixth loan amendment, is no longer a covered loan, because the CARES Act defines a covered loan as relevant here as one that is guaranteed under section 636A, which is the 7A loan program. And so once the SBA is no longer guaranteeing that loan, once it's released from its guarantee, it's no longer a loan guaranteed under section 636A. And so that is separate and apart from the decision on whether the loan should have been moved out of regular servicing status in advance of the first payment date. And I will say the record supports that decision as well, regarding the sixth loan amendment. The terms of that amendment required amounts of principal repayment, $775,000 every month, that plaintiff had never been able to meet and in fact could not meet during the life of the Sixth Amendment, which is more than enough to bear out the SBA's suspicion that the Sixth Loan Amendment was just an attempt by the lender to get the loan off of its books at the federal government's expense. On both grounds, the agency's decision was not arbitrary or capricious. And I would also like to reference briefly, my colleague has focused quite a bit on the May 20.
If it shouldn't have been under the program, would the borrower be susceptible to repaying the SBA the first 2 payments it made?
No, Your Honor. So another thing that the SBA's letter in November 2022 says is it instructs the lender to return those first 2 payments, which the lender has done. And so
they have done that?
Yes.
Okay, that was my question.
Yeah, the plaintiff is not monetarily liable for anything at this point to the SBA. And I just want to briefly touch on the May 2020 payment. As we pointed out in our brief, that is not final agency action that is subject to review under the APA, because that was not the consummation of the agency's decision-making. It had an effect.
What was the date you contend is the final agency action? November 2020?
We would say that would be the final decision letter in November 2022. There was a decision communicated to the plaintiff on its SF-95 administrative claim in December, but the November 2022 decision, I think, was the final decision because the SBA regulates and has a contractual relationship with the lender, not with plaintiff. So yeah, as we said, the May 2020 payment is not final agency action that is reviewable under the APA. It's not the consummation of the agency's decision-making. That decision was consummated in November 2022.
Is the CARES Act has to strike a careful balance here because on the one hand, Congress wanted these loan guarantees because the loan guarantees were necessary for small businesses to receive the capital that would keep them afloat during a really rough time because the pandemic and COVID had really thrown small businesses into a perilous situation, and the loan guarantees were essential to really to the survival of many of these small businesses. But then On the other hand, this kind of legislation is also subject to abuse. And I said, I'm not sure that the CARES Act and I think the regular servicing requirement backs that up. I'm not sure that the CARES Act was meant to simply absolve lending institutions of the need to follow some sound banking practice when it loaned money and serviced those loans. So you have that very difficult balance here, and I can understand it from the standpoint of what the CARES Act was designed to accomplish. But also, it seems to me that both the regulations and the legislation didn't want even the most dysfunctional and irresponsible lending practices to be reimbursed by the government, and that the lenders can't just come to the government to get loans that were never regularly serviced and lean on the government to get, as you put it, a bad loan off the books. So the question is, who strikes the balance? And if you have a 2-year agency investigation and all of these amendments and everything and the rest, that seems to me within the parameters of the statute to have the agency strike that kind of balance between making the capital available and not having it just taxpayer money just thrown out willy-nilly. And I think the agency's entrusted with that kind of balance, and the regular servicing requirement seems to indicate that there is at least a modest check on very bad loans. I mean, that's about the way I can figure it, a difficult balance that an agency has some latitude through its regular servicing requirement to implementing.
I see my time's expired, Judge Wilkinson. May I answer your question?
Yeah.
It will be unsurprising. I agree with you wholeheartedly. I think Congress did strike a balance. You see it on the face of the CARES Act that the idea was to help otherwise healthy loans, and by that I mean those in regular servicing status, weather the storm of COVID and the measures that were implemented in response to it. In terms of determining whether a loan was in regular servicing status, that's absolutely the agency that strikes that balance because they have the factual expertise to bring to bear on the specialized world of small business lending, which involves things like prudent lending standards, cost-efficient exercise of remedies. And I would point out that even one of the plaintiff's favorite cases to cite, Motor Vehicle Manufacturers Associations, says the courts defer to factual areas within the agency's expertise. In that case, it was NHTSA's view on motor vehicle safety regulations. But Your Honor's right.
My impression is that these loan guarantees offered lenders were in the great majority of cases honored, where this strikes me as a bit unusual, because where the loans were extended under a loan guarantee, in most cases, simply as an empirical matter, as I understand it, the loan guarantees were honored by the government. The lender was reimbursed. Is my impression correct?
As far as I understand, that is correct. And as I said, had the SBA's investigation revealed nothing more than a bona fide reporting error by plaintiff's lender, the SBA would have honored the guarantee in this case, again, assuming that there were still appropriated funds available. But it was that the SBA...
I mean, if the agency is in some kind of, engaged in some kind of practice here of denying loan guarantees that it has extended and offered to lenders, then that's pretty disturbing. But on the other hand, if we, say, well, yeah, you've got to honor the loan guarantee, we're almost saying, well, anything goes. And I'm not comfortable with either of those, what I think are more absolute positions. And the Congress left it to the agency's expertise to resolve what is a difficult balance, and it's not as if you just sort of blew these parties off. You undertook a long investigation. It's a very extensive administrative record here. And we're under an arbitrary and capricious standard, which is at least deferential to it's a fair or substantial evidence standard, which are deferential to a considerable extent. And we have to find that the lengthy investigation, the lengthy record that was compiled are all just, we have to just, to reverse you have to just blow all that off and say, well, this is arbitrary and capricious. And I'm not sure I see it, because a lot of times I say, well, maybe I would have made a different decision had I been on the ground floor, but I'm not on the ground floor. And it's just, that's just my thought here, is that there's Congress entrusted the agency to strike that balance.
I believe that's right, Your Honor. At this point, I'm well over my time, unless the court has any further questions. We're happy to rest in our brief.
Judge Berner, do you have further questions?
No, thank you.
All right.
Thank you, Your Honor.
Mr. Johns, you have some rebuttal time.
Yes, Your Honor, thank you. There's a number of things to point out from my friend's presentation. There's a chronology in the joint appendix, page 185, that shows that the Sixth Amendment was approved. The Sixth Amendment was approved on the 22nd of May, 2020. It was put in place. The payments for April and May were actually made on June 1st of 2020. So they were made after that Sixth Amendment was put in place, going to Judge Berner's
They were made
question.
by the SBA?
Made by the SBA, that's correct.
Now, as I understand the position of the government here, there was some action taken in April or May, and you focus on that enormously, where they stopped payments.
Yes.
And you say there's no reason to indicate that. And as I gather their argument and your argument placed, I'll tell you what I understand, then you can correct me. But their position is what they got information from the bank that indicated a default position, which is curious, and they accept that. But they say that went to Colson, I guess, and Colson reported it as a problem. And even though SBA was making payments at the time, that prompted an inquiry, and the preliminary inquiry led to a larger inquiry. So that was not necessarily a causative event for disqualifying the loan. What it did is it perhaps unwittingly opened up an investigation, but the investigation disclosed that the loan was inappropriate. And what we review is the final agency action decided on November to see whether the agency reached the right conclusion under the standard of review that we have. Your position is that it would have never been uncovered had the agency not reacted in April or May to that report from the bank. And that's a little bit curious, because even if you're right, there was an investigation that disclosed the loan was an inappropriate one for the CARES Act. At least that's what the agency takes. But we would review that issue based on the November finding, November 22. Your argument is that that's arbitrary and capricious because the whole investigation was initiated by an unsupported act. Is that the right way to understand the two positions?
That's not quite our argument, Your Honor. Actually, the investigation that counsel refers to was initiated after PASM filed their Form 95. So and we think the final action, stopping the payments, I think when we look at the case law, that was the consummation of their activity. They can't stop paying them any more than not paying them.
Well,
The two
let's
payments.
just assume it's accidental. Unfortunate, something peculiar happened, but it did start an investigation. They stopped payments, and people looked into it, and I think as early as August or September of that year, people were already noting that whether this loan qualified at all.
Well, the May 21 letter says that it was stopped because the loan was in default.
Right.
The loan was in default
Let's assume that's a mistake.
because there were no payments
Yeah,
made.
but let's assume that's a mistake. Their position is it doesn't matter because there was nothing untoward from the agency's point of view. They were acting responsively to various information received, and they received a 1502 through Colson, which indicated it was in default. And so the question is, what's going on here? And when they look into it, that leads to things that question the entire loan guarantee.
Well, we would, in response to that, we would say even if that is the case, the SBA, if deference must be paid to the SBA in their determination of these loans, then we would look at Joint Appendix 198, which lays out the SBA's own criteria for what is when a loan is not in regular servicing. And it says it's either, if it's moved from regular servicing into liquidation status, which had not happened at the time that the loan was, the payments were stopped. And then again, the loan is in regular servicing status as long as it's not more than 120 days past due. There's no lemon loan provision in here to say, well, it's not in regular servicing because we should have done a better job vetting it. And I'm not arguing that there was a bad job done. What I'm saying is, if the court is going to say, well, we have to give deference to the SBA in this, and we are in a post-Loper world, if we're going to say we have to give the deference to the agency on this, then let's look at what the agency actually says about when a loan is in regular servicing. So I think those are also crucial if we're going to say, well, the retroactive decision takes place a year later. The other point, Your Honor, is that in that process, there was no opportunity for PASM to participate at all. They submitted the Form 95 and then later on received a decision. There was no one
All right,
reached out to
we
PASM.
we
I
understand that
apologize, Your Honor.
from you.
I'm over time.
You've been over it in your brief and elsewhere. I'm going to ask my colleagues if they have further questions. Judge Bernard, do you have any additional questions you'd like to ask?
No, thank you.
I'm fine.
I think we're fine.
Thanks for the court's time.
We will come down and re-counsel, and then we'll take a brief recess.
This honorable court will take a brief recess. the judges of the United States Court of Appeals for the Fourth Circuit.
Please be seated. Okay, McKenna versus Kugle case. Mr. Ruszkowski,
Yes, Your Honor.
pleased to hear from you.
I'm sorry, Your Honor?
Whenever you're ready.
May it please the court, my name is John Ruszkowski, and
Can you move it down just a little tad?
Is that better, Your
That's perfect.
may it please the court, my name is John Ruszkowski, and I represent the appellant, McKenna Vekimye Industrizi, or MKE for short. We're here to address what is an unambiguous and express contract in three separate ways, Your Honors. It is a contract that had an express installment contract relating to the delivery of up to 4 shipments of weapons. It had an express installment contract that separately addressed the payment of a long-due debt, 13 different installments that were due relating to that debt. And it also had an express provision relating to termination, all of which were followed in this case. Notwithstanding the fact that this was an express and unambiguous contract, MKE submits that the district court erred in 3 respects. First of all, the district court gave 3 instructions that were not supported by the law or by the facts in this case, considering the clear and unambiguous contract. Second, the district court erred by not granting MKE's Rule 50B or Rule 50 motion in that regard. And third, somewhat in relation to that, Your Honors, as well, we identified some erroneous and prejudicial evidence that also supported or was allowed to help with the wayward jury verdict in this case. Going back to the contract itself, we mentioned at the outset there's 3 different express parts of it. One part of that was relating to 4 potential shipments, and the evidence clearly showed that those shipments required a firm schedule. That was something that not only MKE introduced, but Zenith, the defendant, introduced as part of its case to confirm that that firm schedule required a 40% payment 3 months in advance. For the first 2 shipments after the contract was signed, Zenith missed both of those payments. For one of them,
Except that the contract required 40 days in advance, and the first shipment was, how soon after the contract was signed? When was the first shipment?
so I'll take a step back. It was
My
4 months
question is-
before.
My question to you is, when was the first shipment after the contract was signed?
The first shipment after the contract signed was March 11th.
And
The
when was
contract
signed?
was signed February 7th.
Okay, so you couldn't follow the 40 days then?
Understood, but Your Honor, well, let me address those 2 payments separately, because they really are addressed separately. There were 2 payments that would have been due before the contract was signed. Nothing stopped Zenith from making those payments before the contract was signed, whether on a purchase order basis or otherwise. But those 2 payments don't establish a course of conduct or a course of performance, if that's what Your Honor is driving at, Judge Neumeier.
No, the contract seems to be an integrated contract that connects the payment of the debt to the receipt of monies for the sale of the arms and pistols. In other words, the idea was they would be sold and the proceeds would be used to pay the debt. And so if there was a delay in the shipments, there should be an adjustment in the payment of debts, and that was explicit in the contract. This was all presented to the jury, and the real question is, we're not here to decide whether your argument is right or wrong. I think we're decide was there evidence for the jury to conclude, and you're not even challenging that. You're really, I'm not sure what is before us, because you probably have to start with your Rule 50A motion.
Sure.
And your Rule 50A motion challenged damages, and thereafter, you tried to expand it to other grounds, but I'm not sure that's possible.
So let me take a step back, Your Honor, because first of all, I do want to push back in terms of your comments relating to the contract itself. The contract did not link those 2 together. And how do we know that? We know that for 3 reasons, Your Honor. First of all, the contract itself does not link them, and I'll walk through that language.
Well, it says, I really don't want to debate the contract, but I do know the contract says that if the shipment is delayed for various reasons, that the payment schedule will be adjusted. It says that in the contract.
It says if there is a
Okay.
shipment delay, there
Yeah.
will be a delay in the payment
Yeah,
schedule. But-
and that's indicative of some kind of linkage. They're not so independent as you maintain, but quite apart from all of that, you argued this to the jury, and the jury ruled against you.
Well, Your Honor, but what we're addressing here, and that's why I started with the jury instructions. The jury instructions in this case were incorrect as a matter of law and also unsupported by the facts. But first of all, let me just briefly step back, because I do want to address your question or your comment head on. You're correct that it says if there's a shipment delay, that there will also be a consequent delay in the payment schedule. But we need to look at what actually happened here, and that's why those facts don't support the jury instructions in this matter. First of all, in terms of Ms. Kaya was the CEO of the entity Zenith. She admitted at both page 3162 and 3174 of the record that they were not linked. The direct question was asked of her where she kept saying, I wanted to get this, but MKE would not allow it. In other words, she's talking about hopes and dreams and aspirations, not what was actually in the contract. Page 3174, she expressly admitted that those two did not go hand in hand. In direct answer to Your Honor's question, Your Honor, similarly, the fact if there was an allegation of a payment delay or a shipment delay that fails for two separate reasons, and again, that goes to the heart of the jury instructions and the Rule 50A motion that we submitted relating to damages and relating to the issues that are being brought here. First of all, in terms of the first shipment.
The Rule 50A motion didn't actually relate to the issues that are being brought here, isn't that right?
I disagree respectfully, Your Honor, because we're certainly challenging the damages award. Second of all, if you look at the record, and I want to make sure I get the correct cites for you, at both page 3240 and 3244 of the record, I'd encourage you to take a look at those, where as part of that discussion with Judge Ballou, we expressly addressed the question of whether these went hand in hand, addressed the fact that they do not as part of that Rule 50 motion, as well as the fact that there's no path here, simply no path here to argue whether as a matter of fairness or as a matter of contract law, that Zenith would be able to escape a 5-year-old debt for ammunition that totaled over $3 million by making a claim for a $30,000 warranty claim, and go directly to Judge Neumeyer to your question or comment. March 11th was when that shipment was delivered. March 21st is when Zenith admitted as part of the record it delivered it to its customers. So even if Zenith claimed there was a 10-day delay, they don't get to take a 10-day delay in March and say, I get a get-out-of-jail-free
You're
card in
arguing,
July.
number one, you're treating my question as something that's a core, and it's not. I was questioning the linkage type of thing. But the more important question is there was an argument as to who breached first and so forth. And it seemed to be unrebutted that the shipments, first two shipments, had defective product. And that caused her not only expense, but caused her a delay in getting income from her customers. And that was all presented to the jury as the reason for this and that. And you made all these arguments, but my question to you, this is a core question, is do we have anything before us other than, well, you have your evidentiary rulings and your jury instructions, but the Rule 50A motion you made, you summarized it 2 or 3 times as a motion relating to damages. And the question is now, are you precluded on a JNOV from arguing anything else? And I'm not sure you are, but you're welcome to address that issue.
Sure, and I started to address that hopefully with Judge Berner, but the answer is we are for 2 reasons. First of all, certainly, as Your Honor mentioned, the JNOV did address damages, and it specifically addressed one of the aspects of the damages that ultimately were awarded in this case, one that Judge Ballou even noted was very close, and even said this is something we may need to look at after the trial. That's why we're here, because we're looking at after the trial, because there's no basis for those damages to have been awarded. So that's certainly one of the questions before Your Honor. Jury instructions are also here in front of Your Honor. That jury instruction conference happened after the Rule 50 motion. There were timely objections made both during the trial and after trial in those regards, so those remain as well. As I was referencing to Judge Berner, I would submit that if you take a look at pages 3240 and 3244 of the record, we also did address as part of that Rule 40 motion the arguments being made by Zenith relating to the idea that these go hand in hand, pointing out the very same testimony I shared with Your Honor where Ms. Kaya admitted that that language was not in the agreement, as well as the fact she tried to put that language in the agreement and MKE said no. So here we have an express and unambiguous contract. So under those circumstances, I would submit that both those contract issues are still before you, but frankly, they also overlap with the jury instruction issues in the first place, because there was no appropriate basis to provide jury instruction 24 relating to good faith. All the acts that we're discussing here are express contractual rights. Discretion does not get involved here. There's no discretion when it comes to the fact, and we cited a number of cases for you as part of the briefing. If every express contractual right, the right to terminate, the right to say, no, you missed that shipping window, became somehow a discretionary act, that would override the entire rule. So we pointed out as a matter of law, there's no basis, and taking a step back to the good faith and fair dealing instruction. It was incorrect, first of all, as a matter of law. The reference to dishonesty had nothing to do with this case, was an improper instruction, as well as the final penultimate statement that the failure to act in good faith constitutes a breach of contract. Now, Zenith, to their credit in their appellate brief, does not disagree, or frankly agrees, that the first statement was an inappropriate or an inaccurate statement of law. Zenith takes issue with the last sentence, our challenge to the last sentence, but that's clearly not what Virginia law states. The failure to act in good faith does not constitute a breach of contract, especially when one acts pursuant to an express statutory right. And here, we had an express statutory right, an express contractual right, where Zenith said, if we want to buy firearms for you, we were going to buy them 3 months or pay a down payment 3 months in advance. They didn't do so despite reminders to them on March the 15th, March the 27th, including reminding them we're waiting urgently for that payment, April the 4th, April the 24th, and May the 24th. All part of the record, the part of the factual record that must be considered in terms of whether a jury instruction is appropriate or not. Here it was not, because the law did not allow for that. And what's left at that point, Your Honor? And I'll get to your point as well about whether this shipment delay leads to a payment delay. The shipment schedule had 4 shipments. The first 2 shipments were made. Zenith received both of them, and both of them were in Zenith's customer hands within 10 days. Even if Zenith somehow argued there was a delay, you're talking at most 10 days, and I'll get back to that in a second. But the second 2 shipments were off the table because the contract expressly said, firm schedule. Ms. Kaya admitted a firm schedule, admitted that there was no right to receive anything after they missed those windows for those 2 payments. I'm talking about the shipment payments, not the debt payments. At that point, there's nothing else left in this contract other than the debt they still owe to MKE.
Well, there was evidence, I thought, relating to the 3rd shipment, or June shipment it was, and the reduction in the amount and a payment of $5,378.
Slightly different. It was a $578,000 payment, Your Honor.
$578,000.
And so what happened there is after 5 separate reminders that they had missed the window, and again,
But that was indicated, that payment was sent as a down payment for the forthcoming shipment, right?
it was indicated as a down payment for part of what was requested, the shipment.
Well,
So there's 2 issues.
That was a disputed fact.
Correct, so.
But she thought it was a legitimate down payment based on the adjustment. But quite apart from that, that's for the jury to decide. But the question is, that was made for that 3rd shipment, and the 3rd shipment never came. Rather, your client applied the money to the debt.
They did, and Your Honor, I'll get back to the prior question that I was answering, because I'll address that one head-on right now. That $578,000 payment was not only late, but it was incomplete. In other words, instead of being...
You accepted it.
We received it, and what we said to them is that if you want to now fulfill the other orders, because they also had missed the July payment window, you need to pay us for both, and then we'll negotiate a new shipping schedule. Because at this point, the shipment schedule was out the window. If you look at that shipment schedule, it set those defined months not just arbitrarily, but for a reason, because my client, first of all, had to pay subcontractors to help create those weapons. But second of all, if you look at attachment 2 to the contract, it has express windows in there where we have other contractual commitments to make, both the draft and otherwise, including to the Turkish Ministry of Defense. So this wasn't, we hold this date open. The contract doesn't say if you pay us, we give you weapons 3 months later.
You've thrown all kinds of claims at your opponents, and I just wondered particularly with respect to your trademark infringement claim, what was wrong with the jury's resolution of that? Because MKA, the argument was made that MKA knew of Zenith's use of the trademark at the trade show, and didn't object. Do you have a problem with that?
We do, Your Honor. I'll address that briefly, but then I'll turn back to the contract issue. The testimony was they did object very vociferously, but it was etched into the window and they didn't make a show of it. But
did
even
you-
leaving
did you-
that aside.
Did you know of the trademark, that it was being used at the show?
We did not know before. They then learned when they arrived at the trade show, and it was still being featured there, in which there was as it was described as an altercation. But no one said tear that down. The bigger focus of the trademark issue, Your Honor, as I'd submit, is you look at the evidence that followed. A cease and desist letter that was sent that followed, and even following that cease and desist letter, Zenith continued to list on its website MKE weapons that it listed as out of stock, but said, hey, email us to be put on our wait list. So at a time where Zenith had been terminated, had been told not to use it, had received a cease and desist.
Did you present all that to the jury?
We did, Your Honor. That's why, if, with Your Honor's permission, I'm going to turn back to the contract issues, although it looks like I may be out of time.
All right, if you don't want to talk about the trademark infringement and false advertising and the rest, it's up to you.
I would submit on our briefs, we submitted that evidence, and what the argument I just put in front of you was the timing in terms of what happened. The SHOT Show certainly is part of the story, but if you continue to act after a cease and desist and list something on your website that's out of stock and say, but nonetheless, hey, email us to be put on our wait list, they're using MKE's name and trademark to try and create confusion and in an unfair and proper way, as well as we've identified some of the articles they were publishing on Facebook and the like in September, where they continued to draw consumer interest to them by using MKE's name even after year after the termination and after the cease and desist.
Zenith's response to that was that the exclusivity provision did not bring an end to the relationship. And wasn't that the question before the jury?
No, Zenith said it was fair use. Zenith argued it was fair use to continue to sell product that they had, but that still, frankly, I guess to use my dad's old word, that dog didn't hunt, because they were listing out-of-stock weapons. You can't sell out-of-stock weapons that are out of stock. They were using it to drive MKA's name to their own website. With that, Your Honor, I see I am a little bit out of time. I'd like to reserve some of my rebuttal time to address further contract issues and jury instruction issues with the panel, with your permission.
That sounds fine.
Thank you, Your Honor.
Mr. Mayo?
May it please the court, my name is Evan Mayo. I represent Zenith Quest International, Zenith Quest Corporation, Lake Kaya, and Zenith Firearms, Inc. I'm going to adopt the nomenclature of the trial court and the parties and simply refer to all of those companies and their subsidiaries as Zenith, as was done throughout the briefing. I think the court's questions to esteemed opposing counsel are the same ones that the appellees have after reading the opening brief. Is, you know, many of these arguments are simply repackaged jury arguments that that MKE had an opportunity to make, that they did quite capably make at the trial court level.
What about their argument on the erroneous instruction with respect to good faith? And, you know, it's a basic principle of contract law that an implied covenant of good faith attaches to contracts, but the implied covenant of good faith can't control the clear terms. Was that an erroneous instruction?
I don't believe the instruction was.
Because what you don't want is you don't want a contractual relationship. Just you don't want to shift the focus from the contract itself and have it become some sort of mushy debate over the respective good faith of the trials, and that's the danger in these good faith instructions, is that they draw the jury's attention away from the actual text of the document. And so why was the good faith instruction here? Why was that legitimate exercise of the court's discretion?
Thank you, Your Honor. I understand the question, and my answer is that the instruction could have been phrased differently, and perhaps different counsel in that position would have phrased it differently, but we're still a far sight from error or an abuse of discretion. There's no evidence at all because MKA...
Was the instruction erroneous?
No, we don't believe the instruction was erroneous, but in the alternative, if it were, we've argued that it was harmless.
Well, tell me why why do you think the instruction was not erroneous?
Because it was an accurate statement of the background law in Virginia, that the implied covenant of good faith and fair dealing is read into contracts.
But Virginia doesn't allow a loose good faith instruction to just take over the trial.
I agree with Your Honor with that statement of the background law, but specifically with MKE, I disagree that there's evidence in the record that that's what happened here. MKE would be in a better position if they had requested a special verdict form or some type of categorical, even a more granular liability verdict sheet, such that we could have ascertained that the jury determined that there was a breach of the implied covenant of good faith and fair dealing. That's not what happened. They simply ruled that MKE breached and that Zenith did not. And so there's not enough there to attribute
So was
harm.
the correction in the special verdict form, or where was the jury's attention drawn back to the terms of the agreement?
I think
At the end of the instruction, did the court not say that the good faith could not, I'm reading from the instruction, could not be implied to vary or contradict an express contractual right or obligation? Wasn't that also contained in the jury instruction?
Yes, Your Honor. Excuse me, yes, Justice Berner, that's correct. And so I think that mitigates the concern that
I thought your point was
panels
that
raised.
the good faith instruction had applied to discrete acts rather than to the contract as a whole.
I think that's the position of MKE, is that the jury must have relied on this implied duty to find breach, because there's no way they could have ruled against them on the express provisions of the contract. I disagree completely with that position, having reviewed the record. I think there was a number of independent bases on which the jury might have concluded that MKE violated the express provisions of the contract.
Well, Judge Berner makes a good point, doesn't she? About the mitigating and the fact that the jury instructions ultimately mitigated it and drew the jury's attention to the essential fact.
Yes, Your Honor.
Your point has to be, I think, in this whole business, that we had a nine-day jury trial, and we can quibble over this, or we can quibble over that, and there are innumerable claims on appeal. But we had a 9-day trial, and sometimes you think, well, this should have been resulted, sometimes there's always a sort of a tension between whether contractual issues should be resolved by the court alone as a matter of law, or whether you actually send them to trial. And that's a close call sometimes. But the district court decided to send this one to trial, that there were enough issues he wanted to take a jury, for the jury to take a look at. And I think the best expression of your position is that all sides got to put in their evidence, so they got to submit their respective positions before the jury, and that remanding this case, it's the old expression that Justice Rehnquist always used: you're entitled to a fair trial, but you're not entitled to a perfect one. And sometimes the perfect is the enemy of the good. And remanding this case, are we really going to reach any better result than we have here? What would be the point? It's not going to be a better result. I mean, sometimes you just look at a case as a whole and you say, well, yes, rough justice was done. I think that's your strongest argument, if I might suggest it.
I wish I could have put it in those words, but I think particularly what the court had to say about not a perfect trial, but a fair trial is what I was reaching for in answering Judge Niemeyer's question, which is the instruction wasn't perfect, no, but it also wasn't erroneous. There was a balancing and a tension between the part of the instruction that MKE didn't like.
That's what I was trying to ask you. You say it's not perfect. I'd like to know what part you think was wrong. The court said it may not vary the terms of the contract, and the Supreme Court of Virginia has clearly said it's an implied covenant of good faith, and that any contract provision performed dishonestly will violate that.
I want to clarify that I don't think the instruction was wrong. I think that there were there was a range of acceptable instructions that could have been given on that point that wouldn't support an appeal, and the one that we have is one of them. As someone who does trial work as well, there's sometimes a decision to make about, do I want the instruction that's going to be maximally helpful to me with the jury but raises the risk of an appeal, or do I want the very safe instruction that will essentially foreclose an appeal but might be of less use to me in trying to establish liability or some quantum of damages? The trial counsel on both sides were capable here. I know that they ran that calculation, and the one that was ultimately submitted is within the range of instructions that are not erroneous, and ultimately led to the jury verdict. And the verdict itself, I think, is illustrative. It was related to an amount that Zenith had attached to a theory of liability based on express breach, that the 12-month delay coming from MKE saying we wouldn't be able to deliver these not for 3 months, but for an additional 9 months after that.
Well, there was no question here that many of the arms shipments, a number of them were delayed. And in some cases, there was no failure. There was a failure altogether to make a scheduled shipment. And the whole terms of payment in the contract were interlocking with the timeliness of the shipment and the quality of the item shipped. And so the jury heard a good deal of testimony here about the actual date and the time and shipments, and also whether the arms and the items shipped were defective. And that again, they came down. They had to have come down in your favor on that, and that was an effective counter to the fact that there'd been any breach, because you presented with something that the jury apparently felt was a very justified argument, or in your behalf, that the breaching party initially was your opponent.
I agree with that summation, Your Honor. Plainly, a 90-day delay was workable for both sides, from a delay of supply to wholesale or retail sales. 99 more months or 270 more days is just a whole different league, and I think that must have been part of the jury's evaluation, that they planned around this 3-month schedule. There was also the testimony from MKE's own representative that a 12-month delay was not anticipated or contemplated as part of the contract, which would tend to cut against Mr. Viscuski's argument that we need to evaluate the sort of strict liability standard of breach under the agreement.
I will say I'm struggling to understand the counterclaim damages award. Even if MK breached the contract first, how does that breach then wipe away the $4 million in debt that Zenith owed to MKE for the unpaid invoices? Can you walk me through the evidence that supports the damage award on the counterclaim?
Yes, Your Honor. So there was evidence on the lost profits relating to the shipments that weren't made. I think there was a shipment of 1,700 guns or firearms that were supposed to be delivered, and in total, 3,600. In closing, Zenith's counsel argued that there were lost profits attributable to those 3,600 firearms that were approximated at $1.5 million was the number that was requested there. There was also the loss of the 40% down payment, which was improperly, in Zenith's view, applied to the outstanding debt as opposed to being treated as a down payment on those future firearms deliveries. I believe there was also evidence.
How much was that down payment?
It was $578,000.
So the components of the damage award here that you asked for were the lost profits and the June shipment down payment and the cost of the delayed firearms part, and the cost of warranty work and processing for March and May shipments. And then I think you were right to say that these different components of the damage award were supported by, in some cases, warranty reports. And in other cases, a witness testimony, and you had cost spreadsheets. So, you had these different components of the damage award, and there were different kinds of evidence that supported each one of them. In some cases, there were warranties. In other cases, you had cost spreadsheets, and in other cases, you had witness testimonies. But there was a foundation for them. I just come back to the question, I don't know what we would accomplish by sending this back. Just as a practical matter. I can quibble around the edges, I could, but, taking the thing as a whole, what good could we do? We sort of leave very well done alone. This is a very, you can't read this transcript without recognizing that this is a very fine trial judge. He's really good.
I haven't had the pleasure of practicing before Judge Ballou before, but I've read his opinions, and certainly the one he did in this case we thought was well-reasoned.
We're not vouching for him, but we're saying that the record reflects, I'm saying that the record reflects a trial judge who's really good at his job.
I agree with the court's assessment and would state also, we haven't talked about the waiver issue, but Judge Niemeyer did bring it up, and I think it's important to evaluate. To me, there's really two waiver issues in the case. I'm so sorry. Judge Berner, I meant to also, in response to your question, I had one more item I wanted to mention, which was that there was evidence of offset by the foreclosure of the property in Turkey. That was another category of damages that I think would be relevant to your question about how the debt was wiped out, the $2.5 million asset.
That was security for the debt?
I'm sorry, as I stand here today, I cannot recall whether that was collateralized, but I want to be as helpful to the court as I can.
But they used that the proceeds of that sale to offset the debt?
I believe that's correct.
Yeah.
And so the Judge Ballou's opinion here is comprehensive. It mustered the evidence very effectively. The parties did the same in the briefing. I don't really think, I would submit respectfully that it may not be so helpful for me to survey those things. But on the issue of waiver, I think there are two waiver issues. And first is, did MKE waive the right to have the court evaluate the JMOV motion by failing to include it in the opening brief? In the reply brief, MKE says, well, you've used a criminal case here, so it's not relevant.
One thing you sort of get concerned about it is that this was a Turkish arms manufacturer, and you have a foreign party, and you want to make extra sure that the the foreign party receives a fair shake in American courts, just as we hope that an American company would receive a fair shake in Turkish courts. And so, you know, I just allay any concern, if you can, on my part, that the jury verdict here was not the product of prejudice against a foreign arms manufacturer, because it's really important that American courts treat foreign companies fairly. Now, am I right to be concerned here about what animated the jury verdict?
So 2-point no, Your Honor, and let me tell you the reason why I say no, is first, there's none of the, what I'll call markers of a runaway jury or runaway verdict here. I would submit that.
But there were no remarks in closing argument or elsewhere that tried to signal to the jury that this is another country. I mean, there was no signaling of that kind, or was there?
I have to admit, Your Honor, I had not scanned the record specifically for that concern, but I can submit that the Kayas, or Mr. Kaya specifically, is an immigrant from Turkey. The majority of the employees were Turkish. That's how the relationship, the supplier relationship arose. And I would think that that would be a mitigating factor there. The concern might be more acute if we had a company staffed by American citizens, founded by non-naturalized American citizens, and versus a foreign arms manufacturer. But someone who was, for example, prejudiced against Turkey might have reasonably applied that prejudice against both sides, given the origination of the Zenith companies here. Did I answer the court's question?
Yeah, thank you.
Thank you. And so in summation, I would submit that I think that the issue on JMOV is because there was an independent and sufficient ground for the court's judgment, which was that there was a mismatch between 50A and 50B, the Rule 50A and 50B motions submitted by MKE, and that wasn't appealed. We're looking now only at cases of manifest injustice, miscarriage of justice, which is a fairly daunting standard, particularly where, as here, as this court has noted, there's substantial evidence in the record. Respectfully, I think a number of the arguments in the briefing from MKE are simply asking the court to reweigh evidence or to evaluate the strength of evidence, credibility, which wouldn't be appropriate under the standard that should be applied.
All right, thank you. If my colleagues have some questions, I'll ask you. Judge Berner, do you have any questions? Judge Niemeyer, do you have any questions?
Thank you very much.
We don't have a question.
Move that back down. Mr. Mayo's a bit taller than me. Your Honors.
Let me just ask you
Certainly.
before you get started. You raised a lot of issues on appeal, and obviously you're wanted to have everything preserved. But if you were to pick the strongest argument to give you relief, what would that be?
It would be two, Your Honor. It would be the jury instruction and the Rule 50 relating to the damages, Your Honor. The damages aspect of that would be the two that I'm most focused on.
So the setting aside the jury instruction, I must say, I'm not sure that gets you too far because of the cautions that the court gave and the context in which it was given. It seems to me it's consistent with Virginia Supreme Court law, and you can show me a case that it isn't, but the Supreme Court has explicitly approved it in connection with explicit contract terms. But the other issue is basically is your focus is basically the damages were not supported by evidence. Is that the main?
Correct, by the contract or by the evidence. And Your Honor, those overlap to some degree, and that kind of gets into the 3 points that I was going to seek to make during my rebuttal period. But the first one is, look, close is not a fair trial. And just picking up on some of Judge Wilkinson's questions, there were other elements of well. You know, there was elements where during closing and during the trial itself, there were reported references to this on-trop judgment. Judge Ballou had limited that just to the fact of it and how much Zenith had paid, which was about $3.5 million. Nonetheless, Zenith repeatedly published a $38 million number, again to evoke sympathy. Mr. Kaya, who counsel just mentioned, one of the arguments that Judge Ballou threw out was the novation relating to a 2017 claim, and Mr. Kaya was allowed to testify over our objection that he had sold his house or been forced to sell his house to make a payment that MKE was found to have properly received as a novation. So there are a number of other errors. We've raised those in our brief. I think those are all tied into these overall issues. But all three of those jury instruction issues are paramount. They gave the jury a path to ignore the contract, to rely upon sympathy, again, against a foreign defendant. And my client does feel strongly on this. It was a 9-day trial because all my witnesses had to be translated. That led to length, that led to, challenges in that regard. But at the end of the day, we are a country and a state guided by laws. And the law here was not followed. I agree. I like Judge Ballou.
What law was not followed?
The law was not followed in the giving of the good faith instruction, the prevention of...
Tell me what do you have to point to it? I mean, I've read the instruction, I've read the Supreme Court, I haven't read the Supreme Court cases, I've read summaries of them.
Yep.
And I'm trying to find out what you think was erroneous about it.
The final sentence, the penultimate sentence given to the jury was the failure to act in good faith constitutes a breach of contract. That is not a proper statement of law when one considers everything here was an express contractual right. And we've cited to you the Ward's equipment.
But what about Judge Berner's point that an instruction was given to, or the jury was cautioned that good faith would not displace the contractual terms? She made that point, and why isn't that sufficient cure?
Because it's followed by the statement, the failure to act in good faith constitutes a breach of contract. That is not correct as a matter of law. It's also not supportable by the facts here, where all the acts taken were done with express contractual rights. We've cited the Ward's equipment case, that's the Virginia Supreme Court case, as well as various others, like Buffalo Coal and Land and Marine, that, trying to turn an express contractual right into a discretionary
Well, let me
right.
just read you something from the...
Please do.
This is from Virginia Supreme Court. It says that a party could breach the obligation of good faith by exercising express contractual rights dishonestly. And another court said that the implied covenant could be violated if a party performed existing contract terms dishonestly.
And
These are both their reiterations of the implied covenant of good faith. So, and the court did warn that it doesn't displace the contract terms. The idea is that the contract terms themselves were performed in bad faith or dishonestly. And I'm not sure that this wasn't correct. That's why I wanted you to point out, is there some case law that suggests what you, some Virginia case that tells them that was a wrong instruction?
The answer, Your Honor, is yes. And I believe we cited those in the brief. Again, I'd refer you to the Ward's equipment case.
Okay, we'll go look at that.
Certainly,
Okay,
and
sure.
I'd refer to the cases in our brief.
Okay.
Just very briefly in that regard, Your Honor, picking up on Judge Berner's points as well. The $578,000, saying that a $30,000 warranty claim in which they had those weapons into their customers' hands 10 days later somehow allows them to void a 4-year-old, $4 million payment relating to ammunition, that is also why we challenge these instructions, because these instructions, the prevention of performance instruction, they had those weapons. They shipped those weapons. Saying that some of them had some abrasions or a loose handle or something like that, even if that's true,
Well,
that
she
does
made a
not...
trip to Turkey, didn't she?
She did.
I mean, it got to the point where she had to travel all the way across to Turkey to consult on the manufacturing process and to inform and instruct it. This is was more serious than a scratch.
The evidence shows that prior to that, their person there that did the inspection, Ali Kaya, not a relation, but the similar surname, Ali Kaya reviewed and approved those weapons for the May shipment. So the fact saying in one shipment of weapons, you had approximately $30,000 worth of claims, even if that's the sum total, using that to void or try and void a 4-year-old
Well, the
$4 million.
second shipment also had problems, didn't it?
The second shipment, there were allegations about $5,000 worth of problems, again in customers' hands, and Your Honor, picking up on that. After both those shipments were received and then sent to customers and accepted, Zenith made the debt payments in May and June. They don't get to keep a get-out-of-jail-free card to come back in July and say, well, now we want to complain about that March shipment that we sent out to our customers 3 months ago, 10 days after we received it, and use that to extend the payment, especially in a situation, again, 4-year-old debt dealing with a different installment subject, as well.
What was the reference to the property sold in Turkey? How much was that?
That's not in the record, Your Honor, but I'm happy to address that if you'd like me to address it. It's
No,
outside
that's
the
all
record.
right. There was some reference that that was securing the part of the debt.
There was a parallel proceeding in Turkey.
Yeah.
There was a foreclosure of that.
Yeah.
That is not part of the record. There was no evidence put on, but
Okay.
I'm happy to submit something in supplemental briefing just so Your
That's
Honor's
okay.
comfort.
That's okay.
Well, no one's looking to double dip here, but just the point I was trying to make, Your Honor, is when you look at this, at this point, there's nothing left with this contract. They received the first 2 shipments, even though they paid them late. Now, again,
Well, as you make this argument, what point are you trying to make to me?
the point is, at this point, you raised the question, and Judge Wilkinson raised the question, well, don't they get some delay in the debt? And the answer is no.
No, the question is whether the jury had sufficient evidence to reach the conclusion it did.
They did not, and that's the point
And that's your argument, that they didn't.
They
Right.
did not, and in part, they were allowed to go down a wayward path based on erroneous jury instructions with this prevention of performance, where at this point, there was nothing left under this contract. Zenith had paid for 2 shipments, they received those 2 shipments, they sent them to their customers.
All right.
The other 2 customers were set on set specific dates. They don't just get to say, come back later and buy them later. Thank you, Your Honor, I see I'm well over my time, I'm going to quit
Well,
talking.
we thank you,
Thank you, Your Honor.
and we appreciate it, and we will come down and greet you both. Thanks to you both, and then we'll move right directly into our final case.
And may we go over and say, just greet Judge Berner as well. I see she's remote, so.
Mr. Cashdown, happy to hear from you.
Thank you, Your Honor. May it please the court, my name is Jeff Cashton of King and Spalding. I represent Progressive Direct Insurance Company, the appellant defendant. I'd like to reserve 5 minutes for my rebuttal. In this breach of contract lawsuit, plaintiff alleges that she was paid less than she was owed under her automobile insurance policy for her total loss vehicle. The district court abused its discretion in certifying the class. While we make many arguments in our briefs, we're going to focus on 3 in argument unless the court has other questions. First, the policy at issue requires Progressive to pay the insureds the actual cash value of their total loss vehicles. In evaluating predominance, The district court abused its discretion by focusing on plaintiff's challenge to an isolated intermediate step in Progressive's process for estimating actual cash value. The proper focus for this breach of contract action is not any alleged flaws in Progressive's methodology, but whether at the end of the day, the insured was paid actual cash value.
If we agree with you on the standing issue, we would not have to reach the class certification.
That's correct, Your Honor, and that was going to be the third point I was going to address. I was following a little bit of the lead from Mr. Dees, in which that came up last, but I'm happy to address that now, Your Honor.
No, go ahead on the standing point.
Sure, Your Honor. On the standing point, Plaintiff Freeman lacks standing to even bring her claim and just thus cannot represent the class. In addition to her policy with Progressive, Ms. Freeman had a loan payoff and a gap insurance coverage policy. And so when her car was totaled, the insurance companies collectively paid the lender the amount she owed. She was underwater, meaning she owed more than she was going to get for her total loss vehicle. The only amount Ms. Freeman paid was her deductible, which was $2,000, and she agreed in discovery under oath that even if the projected sold adjustment had not been applied, the result would have been the same. She would have received money, it would have been paid directly to her lenders. She would have paid a $2,000 deductible.
So your point is, at the end of the day, there's no harm.
In the end of the day, there's no concrete financial harm that she has suffered that's traceable to the breach she's alleging.
Let me ask you about the breach. I had quite a bit of trouble with that. Everybody seems to conceitedly talk about a breach of contract here. If you look at the policy says we'll pay a loss, total loss for an automobile. And the policy said we agree to pay the actual cash value. They define the actual cash value as the market price. Then the policy says the way we will compute the market price is X. And it says if you don't agree, you can go through this appraisal process, sort of an appraisal arbitration. So if Progressive takes a position, this is the market price, and they even disclose how they computed it, that's not a breach. That's a position as to how they construe it. It's a factual matter, and she can turn that down. She can come with her own assessment of it, and if they disagree and can't reach an agreement, then they go to this arbitration, appraisal arbitration. That's what the policy says, right?
That's essentially correct, Your Honor.
If the company takes a position in computing the market price, that's not a breach. They have an obligation to pay the market price. That's the contract. And the question is, what is the market price? And so the company says, the market price for this car is $19,000, and she says, oh no, I think the market price for my car is $25,000. Now, they can settle it somewhere in between, or if they don't settle it, and this is what the policy provides, if she doesn't agree, then she goes through that appraisal process, which is in the policy, which is you have two appraisers. It's an arbitration of appraisal. So none of that is a breach. What that is a disagreement over the market value.
Your Honor,
So every single insured it has to go through this negotiation. They can accept what Progressive offers, or they don't have to accept it. But every single one's going to be unique.
That's absolutely right, Your Honor. And Judge Niemeyer,
But there's no breach involved, and it can't be in a class because every one of them is unique. You can't have a class. Somebody negotiates this deal and somebody else negotiates this deal, and the only thing that everybody's complaining about is Progressive takes a position that in computing market price, we do A, B, and C. Now, I must say, I think Progressive's got a pretty crazy assessment the way they do the market price. But they're entitled to say what they believe the market price is. Their obligation is to play market. And they say this is the market price, and they have a disclosed process. But the insured doesn't agree to any particular market price. It's just market price. And so the insured can say no. And the policy anticipates it, and it says here, where's the, we may use estimating appraisal and so forth, such system, if any there's a place that says if you don't agree on the market price, then you can go to an appraisal.
That's right, Your
Now,
Honor.
it seems to me, if that's provided in the policy, it can't be a breach to have a disagreement over the market price.
Yeah, Your Honor, I don't fundamentally disagree with you. We represent Progressive, of course, and we agree, and we think the district court did get it right when it held at page 2 of its decision that the policy does not require the use of any specific methodology to estimate actual cash value. And that's what the district court held.
And even if it did, it says, this policy, you have to agree to this. The policy does just the opposite. It says you don't have to agree.
Now, the appraisal provision, I have to be candid with the court. The appraisal provision is not mandatory. And so it is the case, I think, that if Progressive was proved to have not paid actual cash value, then Progressive might have been in breach of the contract.
Where
But
is
your
that in the
point-
policy? I'm just looking,
Well,
trying to...
Your Honor, the limits of liability provision of the policy set forth the amount up to which Progressive has to at least pay, and so it at least has to pay actual cash value.
Well, it has to be, but market, they define actual cash value as market.
That's right. And
So the
and
market price, normally the typical market price is what the market is, where buyers and sellers sell that car.
That's exactly
So
what South
you,
Carolina's
so
law
you look at
says.
20 transactions and it gives you the market price, and you can have a disagreement over that. I mean, you can say, well, this market price, this particular sale was influenced this way. But there is, I'm just looking for that appraisal provision in the policy. I have it before me.
Well, and you're right, Your Honor, that, I mean, what you're putting your finger on and getting exactly right is that ultimately to determine for any individual member of the class, whether or not there was a breach in not paying market value or actual cash value, you have to determine what is the actual cash value of the vehicle.
That's a factual question. That can't be a breach of contract. It's a negotiated item.
It certainly can't be a question that can be resolved commonly across the class. It will require many trials where you have to introduce evidence of what was that particular vehicle worth and what was that person paid and how do you compare the two. And the plaintiffs, they engaged in this charade with the court, and the district court unfortunately went along with it to say the breach is applying the PSA, but as the Seventh Circuit explained in the Cartman case, you don't look at these intermediate steps. Instead, you look at were they paid the amount they were owed
All
or
right,
not.
here's the provision I want to ask you about.
Yes, Your Honor.
It says, if we cannot agree with you, that presumes that there's some negotiation. If we cannot agree with you on the amount of a loss, then you may demand an appraisal of the loss. And then it gives you a process to how that's done, 30 days and this, and you go to appraiser. So it seems to me that your obligation, contractual obligation, is to provide the insured with a market price loss that you determine in good faith is the market price. She can come in and say that I don't agree that loss. I think the loss is valued at much higher. Now, after that point, this says if we cannot agree with you on the amount of the loss, then you go through this process. That looks to me like that's the overture that if they don't go to that, then there might be a breach. But I don't see a breach anywhere in this stream of events. And if there is a breach, it would be the breach to fail to negotiate, I guess, or something. But that's not what they're alleging. They're alleging the fact that Progressive computes its view of the market price with a certain facility. And I must say it's crazy as can be. What you guys do, this predictive of what's being asked and a percentage discount on that, looking future devices. You can just pass that on. That's not material to what I'm talking about.
That does go to the merits, Your Honor, but I will say that we, first of all, it's done by Mitchell, and it's done in
Well, I
connection
know
with
it's done by Mitchell, but you have this, you canvass the asking price for cars and then predict what they'll be sold at. That is crazy. I mean, that's not a market. That's a prediction of some future transaction that you don't know what. When you canvass a dealer and say dealer A is asking $21,000, dealer B is asking $26,000, and then you predict how both of them are going to sell, and then one of them sells is a no-hassle place, so they sell it at their $26,000. You discount that because that's not a fair market price. It is. A purchaser who pays the no-hassle price is a market value.
So, Your Honor, the record does explain that the projected sold adjustment is not
I know, I've read all
applied to
that.
haggle dealers.
Yeah.
It's only applied to dealers who do in fact negotiate, and What J.D. Power
I
does is it
understand,
looks
but
at
the whole
data.
thing is predictive.
It is, Your
And a
Honor.
market is not predictive. A market is actual market price that it's being sold at right now.
But I think you've put your finger, Judge Niemeyer, on the key point, and the key point being that in the end, regardless of how they come up with what the breach of contract should look like, in the end,
Why do you say breach of contract? Give me what you understand as the breach.
Well, again, I'm the defendant, Your Honor, so
I know you,
understand-
but you keep calling it a breach of contract.
Well, I can only read their complaint, Your Honor, and what they say in their complaint the breach is that the breach is the failure to pay actual cash value. And taking
Well,
them at their
how do you
word-
know it's a breach? What if they give $100 over actual cash value? Who's to determine that?
Well, I think it needs to be determined individually by a jury, and I think you'd have to do that individually for each class member, which is why there shouldn't be a class certified here.
Except the policy says that if you don't agree with our loss, you can get an appraisal. Now, why isn't that the resolution of the fact question, and where's the breach
Your
under
Honor,
that structure?
I'd be very happy with an opinion from this court that also comes out that way, because Ms. Freeman
Well, I'm just
did not
troubled
seek
by
a-
the fact that you
Excuse me,
guys are so readily concede the breach.
Let me ask you that. I think my colleague is on to a good point here, that it's not a breach. I mean, this case is constructed so you have argument A. If that fails, you have argument B. If that fails, you have argument C. And each of those arguments presents problems of its own. The first question is whether there's a breach and a mere disagreement over the cost adjustment. That disagreement doesn't mean necessarily that there is a breach. Okay, that's hurdle A. All right, now we get to hurdle B, which is even if there was, assuming that there was a breach, if the violation of a contract by itself is not necessarily a concrete harm, if the individual received what they were due, and she was going to have to pay the $2,000 deductible in any event. So that, I think, is the hurdle B, is if she was compensated for all the different components that she had purchased coverage for, then that's probably we're in the position of saying the mere violation of a contract is not a concrete harm in the kind that the Supreme Court has required. If we get past that, we come to hurdle C, which is the fact that the cost adjustments for all of these different cars are very individuated depending on the car and the market condition and how much of the mileage that the car has driven, the make of the car, this and that. And so you have asking down the road, if this continued as a class action, you're asking for one gigantic headache at the damages phase of the case. And of course, that relates back into the absence of commonality. But as I see it, and I think Judge Niemeyer's point is very well taken, but that only relates to hurdle A. The other two hurdles are just as real.
I think you both see it very clearly, and I think you're right, and the only
Judge,
thing I
may
would
I
add,
add to one more to your little hurdle?
What?
The fact that the contract provides a remedy that hasn't been followed, the appraisal.
and the only thing I would add, Your Honor, is I think that your Judge Wilkinson, your last point about the individual trials, it's not even just damages, it would go to liability too. I think you both see it clearly, and I think that shows that this case, there was an abuse of discretion here in certifying this class. The court below was led astray by arguments And frankly, I think as a result, applied the law incorrectly to this contract. This contract, when properly understood.
But Judge Niemeyer has made a really good point. It does seem to me that the fact that there's a disagreement over the cost adjustment or the disagreement over the amount of the payment, that doesn't indicate a breach of contract. It indicates the beginning of a process.
Yeah, and I think really instructive, Your Honors, is the Lewis decision from the Third Circuit. That was a decision where the court explained exactly what you're saying, that you don't look at these disputes about intermediate steps and use that for a basis for certifying a class. You need to look at what does the contract say in its whole.
But even apart from the certification of the class, we have to ask whether there's some sort of breach or some sort of concrete harm. And if there is no breach, because of Judge Niemeyer's point about this is the inception of a process, but if there's no breach, where's the concrete harm in terms of purposes of standing?
And even here, Your Honor, with Ms. Freeman, even if there were such a breach, there's still no concrete harm. She will be left in the same position she's in now, which is having to pay the $2,000 deductible and her loan otherwise being paid off. It's not like she's going to get some recovery from this theory that she otherwise didn't receive. And so for that reason, she has no standing.
Would there be a subrogation interest of some of these other carriers involved in her gap insurance and that type of thing?
There's been none asserted, Your Honor. And
But
so,
wouldn't that be an argument to counter? In other words, the fact that she has purchased insurance to cover her loss, well, it's actually she's underwater.
her obligation.
Gap, yeah.
Yeah.
That's sort of a collateral source. The question is.
It's not clear. I mean, we did note in our most recent 28J letter that there is South Carolina law making it clear that when a third party satisfies a financial loss, then there's no claim for that financial loss. And so she certainly doesn't have a claim for that. And there's been no indication that her gap insurer has any claim here. You know, if they want to bring a case, I suppose we would deal with that issue then. But the question here is whether Ms. Freeman can represent the class, and we don't think she can. If I may, I'll save my remaining time for
Is she the only representative party?
Yes, Your Honor.
Okay.
All right, thank you.
Thank you.
Hold on a minute, Judge Byrne, I don't want to cut you off. Did you have some
I spoke
questions?
too long.
I'll save my question for rebuttal, thank you.
Okay.
Thank you.
Mr. Phillips?
Thank you, Your Honor, and may it please the court. I had the whole intro, but I have a feeling that we need to jump right into these issues. So which one do you want me to start with, the breach or the Article 3?
Well, let me ask you this.
Okay.
I think all the hurdles that Judge Wilkinson listed are things that you should be prepared to address, but I'm wondering when a contract has an arrangement that says we'll pay market value. If we don't agree on market value, we'll go through an appraisal process.
Respectfully, Your Honor, that's not what it says, right?
It says if we cannot agree with you on the amount of loss.
On the amount of loss, right? There's
Yeah.
no disagreement about the amount of loss here. The disagreement is over the actual cash value of the vehicle. So Progressive.
Well, hold it. The loss is the actual cash value, which is the market value.
No, the actual cash value is the limit of their liability for loss. Typically, loss is measured as the cost to repair or replace. But if that amounts.
To replace, it says to replace it is the actual cash value, to replace it.
So-
And they define actual cash value as the market value.
Correct.
And the market value, so if you've lost your automobile, the policy obligates the insurance company to pay the market value of the vehicle.
Correct. And I agree with Mr. Cashman,
Now,
what he said.
when you talk about market value, that is not a specific number. The market value is something that needs to be determined. And there's a disclosure as to how Progressive will do it, but there is also a provision where if the insured disagrees, he can get an appraiser.
It says either party may invoke an appraisal,
sure.
but you're not required to. We didn't.
Not required to, but
and
why is it a
Progressive didn't
breach
either,
if you have a disagreement?
Because they underpaid actual cash value. They have an independent obligation to pay actual cash value. Progressive is not.
They say it's their actual cash value.
Right.
And you disagree.
And our evidence is that it's not.
Right.
And so
So
you're allowed.
now you have a negotiation. They say the cash value of the car is 19,000 or 25,000, and you say it's 19. So you've computed it 19, no, excuse me, you represent the client. You say it's 25,000,
Right.
they say it's 19. Now, have they breached the contract by saying, we believe the market value is 19?
If our evidence is credited by a jury, then absolutely they breached the contract.
Why?
Because a jury found that the actual cash value was
Well, then they'll
25,000,
award them.
and they only paid 19.
That's not a breach. That's just the amount of loss to pay a loss, and the policy has a process to adjust that loss.
If we get to a jury, and a jury says the
You
actual
have to have a
cash-
breach.
Right, but we're proving the breach, right? We've proved the breach. If the jury says.
If they didn't pay the loss, but if they paid the loss and they said, here's a check for the market value of that vehicle.
Right,
And you say, that's not the market value.
right.
That's a disagreement as to market value. It's not a breach.
If the jury agrees with us, it is.
No, it isn't. That's a factual question.
Right, and if
They
the jury
paid-
resolves that, if a jury.
They say that the loss is bigger. You've suffered more loss. It's a damage. But the fact is, it's part of the coverage, but it's not a breach. There's no determinate amount. In other words, if there was a fixed amount for a car and they didn't pay it, that's a breach.
So-
But the market value, they take a position in good faith that this is the market value. Now, why is that a breach?
Cases over the actual cash value of property have been going to juries for 150 years.
No question about it.
And even when there's appraisal clauses and all
Because
that.
there's a disagreement.
And I will say this, Your Honor, if you're right, they can invoke appraisal or move for summary judgment and say there's been no breach, but that is a merits
You're
question.
trying to form a class of persons, all of whom have different actual cash values, and all of whom have the availability for appraisal, all of whom may have been paid or not, have disagreements. I mean, we're talking about a very highly individualized process to resolve a loss under an insurance policy.
14 courts have certified the class, so I don't think it's a highly individualized process according to those 14 courts. We're about to go to trial on a class action next week. That has been very manageable. It took 2 years, and we're about to go to trial. Also, our understanding, just based on the amount of trials out there that have been around for a very, very long time, where juries say the actual cash value is higher than the insurance company said it was, therefore find that there was a breach. That's why we have a jury. Sure, they could agree with Progressive and it won't be a breach, but they might agree with us, in which case Progressive underpaid the actual cash value and there was a breach and damages. Progressive hasn't invoked appraisal, and we're not required
You're saying
to.
that at this stage in the contract, where there's an obligation on the part of the insurance of Progressive
Right,
to declare, at that point, there's a breach, regardless of the fact that there's a
Correct.
process that could be followed afterward that is essentially can or cannot be followed.
right, and that has never been invoked and has never been argued, and Progressive hasn't tried to go to appraisal. And frankly, in the specific context of the auto insurance, Your Honor, we're talking about $700, $800, $900 underpayment, right? It would be economically irrational for any of these insureds to invoke appraisal, pay for the appraisal costs, pay $500, $600 just to get their $600 that they allege were underpaid. It might not be economically irrational for Progressive to invoke the appraisal, but they haven't done that. But we can't be required, the insureds cannot be required to do something that's optional under their policy.
No, it's not a question you're required. It's just the opposite. It's a question that it recognizes that this is subject to a disagreement.
And
The cash value is subject to disagreement, and if the parties in it says, if we cannot agree with you on the amount of loss, that presumes that that could be a source of a disagreement.
Sure.
Then the contract provides a course of action.
It says that you can
Sure,
resolve the
sure.
disagreement through appraisal, but you're
Or
also.
you can negotiate it.
Or you're allowed to resolve the disagreement
Or you
through a
can go
group
to court.
jury, I mean, which is how it happens a lot of the
But,
time.
yeah,
So-
but have a case, an individual case where there's a disagreement over a market value, go to a class action, doesn't make sense, because every one of those cases are individual.
What the evidence shows is that there is no disagreement on any of the individual valuations of the vehicle except for the projected sold adjustment. So Progressive and the plaintiffs agree on every single aspect of the valuation. The one thing that they disagree about is the projected sold adjustment. Our claim is that that projected sold adjustment is invalid always. They say that it's always valid. The parties, in that sense, agree that this is amenable to class-wide resolution. The question is, should their vendor have been excluding?
Was that the basis of the district court's determination that the class was appropriate?
That's correct, and that determination was not an abuse of discretion. It was consistent with 14 other district courts. This court has said you only abuse your discretion if you make a decision with which no reasonable jurist could agree. We've got the Ninth Circuit and 13 district courts all agreeing with Judge Coggins' decision. The core question here is whether a progressive vendor should have been deleting and excluding the data and calculating that projected sold adjustment. What the Eighth Circuit said in Smith was if it is proven that the projected sold adjustment was based on an artificially false market, in other words, if it was proven that they were not basing it on the overall market, they were basing it on this lowered subset of the market.
The predictive market, sort of,
Right, that would be a breach. And so we have now gotten the evidence that shows that the Eighth Circuit was on a motion to dismiss. They said, yeah.
What if the policy said, in determining, you don't have to agree, but in determining the loss, we're going to ask 3 of our claims adjusters their opinion, and we're going to take the average of our 3 claims adjusters, their opinion, and offer that to you as a loss. If you don't agree, you can go to appraisal. Would that be a breach?
It would depend on if they then did that thing.
No, the policy, you don't agree with the method, but they disclosed the method, which is they said, in determining the market value,
Right.
we are going to ask 3 of our claims adjusters what they believe the value is, and we're going to take the average and offer that to you.
Yeah,
And is that a breach?
not if they did what the contract said. Yeah, if they then got 3 of their adjusters and
Yeah, well, that's what they're doing here.
Their contract, so.
They disclose their method here as to how they're gonna do it. They have an actual paragraph that discloses their methodology.
That's going to be based on the market value
Yeah,
aging condition of the
and,
vehicle.
and,
Absolutely.
right,
The problem here is that they then didn't do that, right? They didn't determine it by market value aging condition. They determined it by an artificially low market of their own invention. That's what the Eighth Circuit said would be a breach if it was proven. We've now got the evidence that that is exactly what happens. And so the core question facing Judge Coggins, and which will ultimately face a jury, is, okay, should they have considered the whole market like we say they should have? Or should they have only have considered the market after they deleted and excluded all the stuff that they didn't like, which was vehicles selling for list price? That's the answer to that question we both think is equally applicable class-wide. Progressive just thinks that it's always correct, and we think that it's always incorrect. As to the Article 3 question, this has been addressed a couple times. We submitted a supplemental authority where that precise question was asked. But the point is, Progressive, if we're right, if her allegations are right, Progressive kept money that they agreed to pay her. That's a financial injury. Now, she might have to turn around to a subrogator and pass it along to them. The Supreme Court was facing a very similar question in the Tyler question.
But where is the breach of contract if the insurance contract does not forbid the utilization of the projected of the PSA in determining the amount of reimbursement? The contract itself does not prohibit this kind of the utilization of this particular tool. It may be weird, it may be odd, but is it contractually forbidden?
What's contractually forbidden is paying less than market value. And so what the projected sold adjustment did is mean that they were paying less than market value. And our evidence is that market value is precisely what they say it is once you just add back in the PSA. So
but
the contract doesn't specifically foreclose all sorts of things that they wouldn't be allowed to do.
The process is laid out in the contract in the event of a dispute and disagreement over the cost adjustment. And have they failed? Has Progressive failed to follow that process in some way?
They failed to pay market value, and they chose not to invoke appraisal, and we chose not to invoke appraisal.
No,
We
but have
decided
they,
to settle it.
in the event of a disagreement, what does the process say?
It says that either party may invoke appraisal. We didn't, we chose not to, and Progressive also chose not to. There are other cases, by the way, out there where the insurance company did invoke appraisal, and those are being litigated as well. And still in court, but they are being litigated. Progressive chose not, we can't make Progressive invoke the appraisal process, and we don't want to. So we're instead resolving it in court, which is our right to go before a jury and try to prove that they breached the contract by paying less than market value. The Article 3 question is, this is not a mere procedural violation, it is a financial injury. If Progressive underpaid an insured, they have a financial harm, they're allowed to sue for that. They may, again, there may be subrogation rights, they may owe child support, they may be turning and giving that money to all sorts of parties, but the point is Progressive doesn't get to keep it. You know, whether it stays with the insured or gets passed on to a third party it has nothing to do with this litigation, and it's not a Progressive's concern. That's what the Supreme Court said in Tyler in a case about a year or two ago, where the city was arguing that because the homeowner had encumbrances that exceeded the damages, that there was no harm, right? That she was just going to have to turn around and give it to the lien holder who had subrogation rights. And the Supreme Court said no.
In the event of the dispute, there's a process. What part of the process do you say that Progressive failed to provide? Did they fail to provide? Did they fail to live up to the process that the insurance contract had promised?
Yes, because they failed to pay the actual cash value of the vehicle.
No. That assumes the question. I'm saying, in the event of a dispute over the actual cash value that you are due, that sets in motion a process.
It does not set in motion a process, Your Honor.
Well, we're trying to find out what part of the process because the consumers understandably haggle with insurance adjusters all the time over just how much is due after a collision. A lot of times
But
they say.
I think the point is that the appraisal and the negotiation that is available are not mandatory terms of the contract. They're simply available as options. And so reading them as mandatory essentially creates some sort of exhaustion requirement within the contract that isn't a mandatory term.
That's
It's
correct.
simply
Progressive, yes.
permissive.
That's right, Your Honor. And Progressive has not included failure to abide by a condition precedent of going through appraisal or something as a defense here. There's simply no question between the parties that if you pay less than actual cash value to breach and you're allowed to sue Progressive. Progressive doesn't even say otherwise.
But it doesn't, there have been plenty of car owners in the millions that disagree with an insurance adjuster.
They would not be part of this class, so they are
Okay, but
excluded from the class if that happens. It happens a lot less than you think, but
the matter doesn't end there. There are always provisions for disputing the insurance adjuster's recommended or the recommended payment. And then what has Progressive not allowed you to, is there no dispute resolution process at all?
there is the ability to invoke an appraisal that either party can do. We have not done that, and Progressive has not done that. There is nothing that says you have to do that before you file a lawsuit. It's simply not in the policy. Progressive has never brought it up. This issue has never been raised. It could not have been an abuse of discretion for Judge Coggins to decline to address an argument that Progressive never presented to him. How is that an abuse of discretion? If they never asked him, they never even brought up appraisal. They never said you can't certify this class because of this appraisal provision. Judge Coggins wasn't required to divine arguments that Progressive wasn't making.
But generally a dispute resolution process would be set forth. It wouldn't be up to Judge Coggins to do it. It would be set forth in the insurance contract.
Well, Progressive didn't do it, and they didn't raise the argument to Judge Coggins, so we're here on an abuse of discretion standard as to the order that he made.
This permissive process of negotiation and appraisal is not a mandatory dispute resolution
Correct.
process as we would consider it in a contract. It's simply another path that an insured can take. And what you're saying is that in the definition of the class, any insured that took that path would not properly be part of the class. The class is simply comprised of individuals who have been aggrieved because the contract was breached at the moment that the essential value of the vehicle was improperly calculated.
That's exactly right, Your Honor. The contract says that we will pay you the actual cash value at the time of loss. So at the time that the accident happens, that vehicle actually right before the accident happens, that vehicle has a market value. Progressive's obligation is to pay what that market value is. They did everything right according to our evidence. The valuation of ACV was exactly right. all the way through, except for the application of this projected sold adjustment. Vast amounts of data shows that that's simply not how the market works anymore. And we have 3 experts who explain that that's not how the market works anymore. Cars are listed at their market price and generally sold for that amount. And so this projected sold adjustment, which was calculated only after Progressive vendor excluded all the data that they didn't like, that application of that projected sold adjustment was the breach. That's the core issue of this dispute. That's why 14 courts have held that these claims are amenable to class treatment. And we would submit that.
And that was the factual evidence upon which the district court relied in certifying the class.
That's exactly right.
That expert testimony was in front of the district court judge.
In fact, they had filed Daubert motions as to, I think, all of our experts. And so he extensively addressed the evidence, even in just the Daubert briefing, prior to then turning to class certification, and then went through all the elements of class certification and pointed to the various expert testimony and data that plaintiff would be relying on to prove her claim. And the relevant standard for predominance under Tyson Food is that the question is if a absent class member were to bring their own individual claim, could they rely on the same evidence that the named plaintiff is relying on? If so, that's a common issue. And in our case, each piece of evidence that the named plaintiff is putting forward, if an absent class member filed their own individual case, they could use the exact same testimony, the exact same expert opinions, and all of that in order to make their claim, which is why this case is amenable to class-wide treatment and can be resolved. That issue can be resolved by a jury in a single trial. I guess my last point would just be to reiterate back to a couple of these arguments that have come up simply were not raised to the district court, and since we're here on an abuse of discretion standard, again, it would be difficult to fault Judge Coggins and say that he made a decision with which no reasonable jurist could agree because he didn't address an argument that had never been raised to him. Progressive hasn't invoked the appraisal clause, and they haven't raised that question before Judge Coggins, so we had no cause to even think of it, let alone address it.
You know, you point out that the commonality is the inclusion of this sort of predictive element in the market, that's the complaint that you're representing basically on behalf of everybody.
Right.
And that is something that's common to all of them. So your argument is basically since they are going to determine the market value of every case using that wrong aspect, you can have a class action.
Right.
But my intuition says that there's something more to this than that. That is part of their determination of a loss that is not subject to contract writing. In other words, the writing is we will give you market value, but market value is a factual question, and they have a method by which they agree to determine that, and the insured may have its own method. It may just go on Kelley Blue Book and go to a couple of others and disagree. And if they can't negotiate it, it clearly is a individualized number for every single car. My problem is, while you do have that common element in the negotiations, the litigation is still going to be determining the market price of cars, which are individualized. Every given case and it's going to be just a mess. There's no collective aspect about it. There's nothing common about each vehicle that's being assessed.
So what the JAMA court in the Ninth Circuit, which also addressed the negotiation adjustment, and what the 13 district courts have pointed out is that you're absolutely right. Valuing a vehicle is an individualized process, right? But Progressive has already done that. In other words, we're not starting from scratch here. They already assessed the value of the vehicle.
And you have assessed the value too. Whether you agree with them or not, you had to make a judgment call.
Right.
And so you guys agree on.
And we say the way that they did it
yeah.
was great. Every step of the process, it was great. This is the only one we disagree on.
But you could disagree, and the reason I pointed to that appraisal provision that says if we cannot agree, the important thing about it, it's not mandatory. Judge Berner's pointed that out, and that's appropriate. The important thing about that, it implies the truth of the matter that it is subject to agreement. In other words, it is an open term. Market value is subject to negotiation and agreement. And the insured does not have to accept it if it doesn't want. In this case, you've made a judgment, you accept it. So we're looking at the term market value, and they say, this is what we think market value is. And you say, nonsense, you've computed it wrong. This is what I say market value. The importance of that provision, if we cannot agree with you on the amount of loss, suggests that it is not a finite term that can be breached. It is a term that can be negotiated. And that indicates a lack of commonality, I would think.
Well, nothing in that provision says that that disagreement cannot be resolved by a jury. That's what it means by not being mandatory, so yes.
Clearly it can, but the
Right.
only point is it indicates the word market value is not a finite term that somebody can predict what it means.
So I would just point to.
Right now, you cannot predict what a market value is in a policy. The market value is subject to termination, and the parties can disagree on that.
Right,
And as you say, they can bypass everything and go to court.
Right.
But my only point about it is that what it does indicate is that market value is an individualized process.
And the only.
And that even though the company uses a common process in their evaluations, the insured will not use that process. They'll use other processes, and they can go to Kelly Blue.
Well, but in this case, we're using the same process. So hypothetically, I guess if an insured wanted to bring their own suit and say, I want to throw a dart at the wall and see what number it hits, and I'm going to say that's the market value of my vehicle, I guess they could, but our evidence that we're presenting
Well,
is.
that's because you've agreed to it, but the point is
Right,
it's
as the class
individualized.
representatives, we're presenting this evidence. Any individual class member could rely on that same evidence were they to bring their own case, which means that it's common to the class, and it's a common method. And one last point that I would make is that class certification is rule on evidence. The only evidence in the record that was presented to Judge Coggins is that Progressive and plaintiffs agree that this is market value except for the PSA. So they agree with the selection of the comp vehicles, they agree with the mileage adjustment, they agree with the condition adjustment, they agree with everything. Progressive doesn't have an appraisal expert in this case. They've pointed to no other methodologies that could have been used. All of that is conjecture and hypothetical, and Judge Coggins wasn't required to rely on hypothetical conjecture or whatever.
Thank you, counsel.
Thank you, Your Honor.
Judge Berner, do you have further questions?
No, thank you.
Let me ask you just preliminarily here. It can't be the end of matters if the insurance adjuster comes in and says, okay, we're going to pay you $6,000 for, the cash value of the car. And then the insured party disagrees with that. That can't mean the end of it. The insured is not required just to sort of meekly accept whatever figure the insurance adjuster puts forward. So what are the next steps, in your view, under the policy for a disagreement over the market value of the car or the cash value of the car? What process does that set in motion?
Your Honor, Progressive does not take the position that we don't have some contractual obligation to pay the limit of our liability. And in this instance, we would have to pay actual cash value.
Put the microphone closer.
We have to pay actual cash value. We understand that. And so if in the end there's a disagreement and they want to bring a lawsuit alleging we have not paid actual cash value, that can be done. The key issue here, though, is whether you can do that on a collective basis, number one, and number two, whether this particular plaintiff, Ms. Freeman, has standing given the unique facts applicable to her. And there's a particular colloquy between Judge Coggins and plaintiff's counsel that's in the record that we point to.
But I want you to answer my question, and my question is, in the event of a disagreement, what is the next step?
Well, the plaintiff both the insured and Progressive have the option, if they want, to invoke the appraisal clause. If neither invokes the appraisal clause, then Progressive makes the payment it thinks is due, and then the insured can accept that payment and move on, or can bring suit if appropriate. Here, Ms. Freeman
So the
expressed no
appraisal-
objection.
So the appraisal process is not a mandatory term of the agreement?
It's not mandatory. We don't say that it is. But what is mandatory, Your Honor, is this. And this is what Judge Coggins asked the plaintiff's counsel below. It's in the record, the joint appendix at 420. The last question at the class certification hearing, question from the court. Would you agree with me that if the defendant paid your clients the actual cash value for their vehicles, as that term is defined in the policy, would you agree there's no breach of contract? And counsel said, I would, Your Honor. And that's the important point. And it may be that my brother may have misspoken. I want to make sure we're clear about what the court below held, Judge Berner, because you asked the question. What the court below held was that the reason why it thought it was appropriate to certify a class is because he thought we don't have to focus on figuring out what the actual cash value is. All that mattered is, do we think the PSA is appropriate or not? And that's wrong. That is focusing on an intermediate step. The contractual obligation is to pay actual cash value, and the question is, did we do it or not? And that can only be determined individually. To Judge Niemeyer's point, there are a lot of individual aspects that go into valuation.
Suppose we take that, that there's an absence of sufficient commonality because the cash value of these automobiles is going to vary. Well, I guess there are different cash values for different markets depending on what actual, geographic location the accident took place in, many different factors. I guess automobiles can be as different as people in some cases. But if we were to say that that the class should not have been certified, where does that leave the suit?
So in our view, if the class should not be certified because those individual issues predominate, we also think, alternatively, that Ms. Freeman herself lacks standing, that her individual case should also be dismissed because she does not have any concrete financial harm. What she's trying to do is simply say, because I have privity of contract, I have enough there.
Okay,
And this court has rejected that. Surprisingly, Judge Coggins cited the Southern District of New York.
Well, okay, but what she's saying is, I have a right eventually to contest the payment that you've offered in court. Now, if we reversed on the class certification issue, doesn't that still leave intact? She would say that still leaves intact her individual right to proceed in court.
It does, Your Honor. We could make the standing argument at that time, but she could then bring an individual suit. And I want to make clear, Judge Berner, that while plaintiff's counsel says we've admitted to the valuation except for the PSA, that's not exactly accurate. We've admitted that our methodology is one way of estimating market value. They want to change our methodology and rip out the PSA, and we have taken the position that that has an adverse impact on the accuracy. But as Judge Niemeyer points out, there are many other methodologies that a jury could use to evaluate market value. The NADA guide is an example, and what we wouldn't do...
I can understand that, but the question I have is, why should we resolve the standing issue if in all events, if we reversed on class certification, she would still have the individual right to go forward in court to contest the amount that you've paid and the cost. So if that right is hers notwithstanding your standing argument, why, I mean, she may not, in a sense, have standing to proceed in this particular action, but what practical difference does it make if she's got the right to go forward and contest the matter in court?
We think, Your Honor, that her breach of contract claim, she still may not have standing individually, but I do think it would be perfectly appropriate for this court to reverse the certification of the class and remand to the district court for further proceedings as to Ms. Freeman's individual claim, and let the district court then address the standing issue or move forward with her individual claim. What is important, as you pointed out, Your Honor, in your decision for this court that Judge Berner participated in Mr. Dees just about a month or two ago, standing issues are important in class certifications as well. And that same issue about standing that we think is troublesome for Ms. Freeman is an individual issue that have to be considered for this whole class.
Okay.
In fact, they're in the record.
Why isn't this court's decision in Netro that was actually written by my good colleague Judge Wilkinson, why doesn't the Netro decision resolve the standing issue? That was a similar case where the plaintiff, if she prevailed, would have to pay the money to someone else, but she was still found to have standing.
Well, I think, Your Honor, that ALEG that Judge Niemeyer wrote is actually more applicable. I think the reason is because the theory here is that they think that actual cash value may not have been paid because they have a dispute about the methodology that we used. Just like in ALEG, there was a dispute about the methodology that was used, the inclusion of individual
Okay, but you're
valuations of
not
houses.
objecting then to a remand to allow the question of individual harm to be pursued by the district court in the course of resolving the standing issue.
For Ms. Freeman alone?
Yes.
We wouldn't object to that, Your Honor. We think what's important at the moment is that we derail this out-of-control class certification
Your
training.
main concern in this case is with the certification of the class. At least that seems to me to be it.
That's correct, Your Honor.
Okay, and the standing issue, which can be a sort of a but I'm not sure that it makes, I think the class certification issue makes a huge practical difference. I think the standing issue becomes a little more academic if she has a right to go into court on an individual basis. And whether she does or she doesn't depends on the question of individual harm, and that's something that can be addressed by the district court on an individual basis on remand. Is that not correct?
I think that's right, Your Honor, and I think that the standing issue is most important for our purposes here because it demonstrates another individualized issue that would predominate if this were certified as a class.
That may be, but independently of the standing issue, there is still a commonality and predominance question.
Correct.
Based simply on the fact that, automobiles, like people, they differ, and they differ in innumerable particulars, depending on the date, depending on where the damage was, depending on the degree to which the methodology may have been used. I mean, they just seem to me that in this case, it's that certification question that matters.
That's right, Your Honor, and to Judge Niemeyer's point, if a jury were forced to handle this case on a class basis and was asked for each individual, were they paid the market value or not, they'd have to consider individual evidence of the value of each vehicle seriatim. And that's just not practical. That's why in the Eighth Circuit, for example, the court described this process as an explosion of predominance issues. That's why, while plaintiff's counsel likes to talk about the 14 district courts that have certified, what he doesn't mention of this court is that there are appellate courts after appellate court in the Ninth Circuit, the Fifth Circuit, the Eighth Circuit, and the Seventh Circuit that have rejected certifying classes like this. And I've made this same argument now in 4 different courts, 3rd, 7th, 9th, and this court on 23F petitions, because this issue is being confused at the district court level.
Has any court addressed this particular issue yet? The circuit court?
The Fifth Circuit has, Your Honor. The Ninth Circuit has in 2 conflicting decisions, Laura and JAMA. In Cartman in the Seventh Circuit, it wasn't involving automobiles, but it was on point. And the Eighth Circuit has as well. But the most recent arguments in the Third Circuit, Seventh Circuit, and the new Ninth Circuit argument, we don't have a decision yet in those. One was, the Third Circuit was argued in November of last year, the Seventh Circuit was argued in December of last year, and the Ninth Circuit was argued last month. And a couple of weeks ago, State Farm argued a very similar issue in the Sixth Circuit.
All right, thank you, counsel.
Thank you, Your Honor.
I don't want to cut off any questions. Judge Berner, do you have any further questions of the attorney here? Judge Niemeyer, do you
No,
have any?
I'm fine, thank you.
Thank you, Your Honors.
We're fine. We'll come down and I'll ask to thank, first of all, I want to thank our good courtroom deputy for this morning's proceedings, and if you will adjourn court, we'll come down and greet counsel.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.